2018. Before joining the commission, he served as chief counsel to Senator John Cornyn of Texas. Commissioner Rohit Chopra was also sworn in on May 2nd, 2018, previously served as a senior fellow at the Consumer Federation of America. And finally, we have Commissioner Rebecca Slaughter, sworn in on May 2nd, 2018. And prior to joining the commission, Commissioner Slaughter served as chief counsel of Senator Chuck Schumer of New York. Our witnesses have a strong fidelity to public service, and they are once again being asked to serve the American people to maintain competitive markets and to protect consumers against unfair and deceptive acts and practices. And again, we thank you very much for being with us today. And at this time now, I'll recognize myself for a 5-minute opening statement. Our hearing today will focus on oversight of the Federal Trade Commission. The FTC functions as the top cop on the beat and keeps consumers safe to promote a vibrant free market in the United States. We look forward to working with FTC on specific issues relating to the subcommittee's jurisdiction, including self-driving cars, data security, the Internet of Things, blockchain technologies, privacy issues, deceptive advertising, Robo Calls, and more. Emerging consumer protection issues are at the forefront of this committee. Recently, I joined Chairman Walden, Chairman Blackburn, and Chairman Harper, sending letters to Apple and Google, asking them to explain how smartphone users' data is protected and when audio recording data and location information is compiled and shared. This morning, we'll be sending letters to location data aggregator Location Smart, Securus, and 3C Interactive Corporation. We continue to remain concerned about cyber crime, estimated to cost millions to the global economy each year, and how business prioritize protecting the most sensitive data they hold about individuals. As we all know, there is no such thing as 100% perfect security. We will continue to work with regulators to understand what transpired in the recent high-profile breaches and what we should learn from these actions for the future. The Economist proclaims the world's most valuable resource is no longer oil, but data. I look forward to a thoughtful discussion on the appropriate steps the FTC is considering, including the chairman's recently announced hearings on 21st century challenges. In my remaining time, I'd like to hear how Chairman Simons will work to utilize the FTC's annual funding to its greatest need and impact, judiciously using the taxpayers' dollars, including on the FTC's current priorities, authorities, and performance, including its human resources, efforts at securing, retaining the best experts in the fields of antitrust and consumer protection. While we are in a challenging fiscal environment, the House Appropriations Committee approved $2 million more to the FTC than the agency requested for fiscal year 2019. I'm also encouraged by the large refunds the FTC has been able to return directly to consumers. Most recently to Uber drivers and customers who bought deceptively marketed bedbug products, consumers in both cases receiving average checks over $200. This is a unique tool in the FTC toolbox. The FTC has returned over $543 million to consumers and deposited $94 million in the U.S. Treasury. FTC orders in the Volkswagen, Amazon, and NetSpend matters require defendants to self-administer consumer refund programs worth more than $11.5 billion. The FTC enforcement authorities are broad and far-reaching. The unique position of the FTC as the civil law enforcement agency for the majority of the U.S. economy cannot be taken lightly. Calls for expanded rulemaking authority, shifting the agency from its expertise in enforcement to regulatory and rulemaking, raises serious questions for me because Congress has explicitly granted the agency rulemaking that has not been utilized in years. Some may argue that the FTC is not equipped to handle the challenge of today, but I believe their actions speak louder than words. The FTC has vigorously defended its jurisdiction and consumers, and we have no reason to believe that will stop anytime soon. Finally, the FTC plays an important enforcement role in the EU-US Privacy Shield framework, particularly relating to compliance and enforcement of U.S. businesses. With a second annual review of the Privacy Shield by the European Commission coming this fall, we want to hear about FTC's and the consumer's role and the commissioner's roles, and what can this committee do to help make sure the 3,100 businesses, including small businesses, continue to have access to the Privacy Shield. Again, at this time, I want to thank our witnesses for being here today. And at this time, I'm going to yield to the Gentlelady from Illinois, the ranking member of the subcommittee, for 5 minutes for an opening statement.
Thank you so much, Mr. Chairman, for holding this hearing on the FTC, and I want to welcome Chairman Simons. I know you're kind of new to the job. I look forward to meeting with you. Today's hearing really comes down to two questions. Is the Federal Trade Commission equipped to fulfill its mission of protecting consumers? And what can Congress do to make it a more effective consumer advocate? The FTC, as to echo the chairman, is the top cop on the beat, protecting both the public and businesses against unfair, deceptive, fraudulent, or anti-competitive practices, through the consumer protection and antitrust authorities. As the economy continues to change and expand, the FTC has had to adapt to this new economy, and as our social networks, shopping, banking, and other forms of communication and businesses move to the internet, the FTC has changed, bringing in more technology experts. At the same time, many suggest that the Commission needs more technology experts, even though its resources are as tight as ever. I'm concerned that we are asking one of our country's most important consumer agencies to choose which protections it will be able to enforce. I hope we will work together to ensure that the FTC has all the resources that it needs to maintain consumer protection and a fair marketplace. From a regulatory standpoint, it's time to look at ways to reduce barriers to FTC consumer protection rulemaking. The FTC's ability to move forward with important rulemaking is much more limited than those at other agencies. In the rapidly changing climate of commerce today, rulemaking must be efficient and timely to keep pace. Specifically, I would like to discuss how well the FTC is protecting consumers' privacy and what they're doing to promote data security. It's my belief that on data security, this committee and Congress should be giving the FTC the tools it needs to do more. Ranking Member Pallone and I have introduced H.R. 3895, the Secure and Protect America's Data Act, which gives the FTC rulemaking authority and civil penalty authority for data security breach notification. These issues are becoming more important for Americans, not less. In our hearing last October with former Equifax CEO Richard Smith, I asked him if, as a consumer, can I opt out of Equifax? After all, I never opted in. Equifax collects my data whether I want them to do it or not, and now my data is at risk of being shared because Equifax failed to adequately protect it. And the answer was sadly, yes. I don't have an opportunity to opt out. It would be one thing if that breach were an isolated incident, and it wasn't. We saw this with Facebook, and we saw this under Uber. Saw this with Uber. In the case of Uber, it actually paid the hackers $100,000 before reporting the incident to the FTC. This can't be standard industry practice. We need to change that power balance by strengthening consumer protections. With the FTC as our partner, we as Congress must work to strengthen the agency to face the 21st century challenges. Many of these new marketplaces, which are often highly concentrated, are failing American consumers. Part of the FTC's mission is the issue of antitrust, and as we saw this morning with the EU leveling $5.1 billion fine on Google, strong consumer protection and robust competition go hand in hand, and that's why Congress and consumer watchdogs must step in. I welcome the new commissioners, Chairman Simon and Commissioner Phillips, Chopra and Slaughter. Did I miss somebody? Commissioner Simons, Phillips, Chopra and Slaughter, and I want to thank Commissioner I'm going to say it wrong, Olhausen, for her work on the commission and her stewardship during the transition. I look forward to hearing your perspective, all of you, on these issues, and I yield back.
Thank you. The gentlelady yields back. The chair now recognizes the gentleman from Oregon, the chairman of the full committee, for 5 minutes for an open
Well,
statement.
good morning, Mr. Chairman, and to the members of the FTC, good morning. Welcome before the Energy and Commerce Committee. We're delighted you're here. We want to welcome our 5 distinguished public servants and welcome to the committee. We got a lot of work to do, and so do you, and so we appreciate your counsel. While our economy is the driver of so much growth and opportunity for Americans, there are still, unfortunately, some bad actors. And the Federal Trade Commission is one of the top cops on the beat. It's charged with a dual mission of competition and consumer protection across large segments of the United States economy and this committee's jurisdiction. So we need an FTC to follow its statutory authority to protect consumers from unfair, deceptive, and anti-competitive practices, both online and off. Recent data security incidents involving Facebook, Equifax, Uber, and other companies continue to raise concerns about the various aspects of protecting consumers in a data-driven economy. I understand the Commission does not, for good reason, comment on open investigations. We won't ask you to do that. But I would emphasize that data security incidents involving sensitive personal and financial information are a significant threat to the United States consumers and businesses, and we are laser focused on these issues here at the Energy and Commerce Committee. The revelations surrounding Facebook and Cambridge Analytica have brought the issue of privacy of consumers' data and information in the age of pervasive social media to the forefront. In fact, Mark Zuckerberg sat in that chair in the middle for 5 hours not long ago. Particularly with Facebook being under a consent order with the FTC, we are closely evaluating the tools used by the Federal Trade Commission in cases as that matter moves forward. 2 weeks ago, we asked Apple CEO Tim Cook and Alphabet CEO Larry Page to explain how their companies use audio recording data as well as locational information collected on iPhone and Android smartphones. Consumers want to know who's tracking them and how. And following reports that location data aggregators obtained locational data from U.S. wireless carriers, in turn selling it to other firms, this morning we will be sending letters to Location Smart, Securus, and 3C Interactive Corporation to probe their data handling and use practices. We have pursued and will continue to pursue important oversight work on these issues, and we will explore the question of whether there are improvements in the current privacy regulations that would increase consumer understanding of how data flows support the global economy. We do not want to unduly saddle companies with unnecessary regulations or impose compliance burdens that will not result in any meaningful impact for consumers, but we will ensure companies are being responsible and that they do not misuse consumer data, period. This is the overreaching reason I support the Federal Communications Commission's Restoring Internet Freedom Order, which reaffirms the FTC's authority over both ISPs, Internet Service Providers, and tech companies alike. This authority is critical for enforcing data privacy practices, promoting a free and open Internet, and protecting consumers from anti-competitive behaviors across the digital ecosystem. So as we consider these issues, I reiterate my invitation to the technology company CEOs. Come to Congress, come to Washington, D.C., engage with us, and talk directly to the committee and the public about your practices. Our goal is to work with all stakeholders on how best to incentivize data security and help protect personal and financial data. So I'm encouraged to have all of you here today because I know you each understand the importance of these issues and the complexity of these issues and the role that the Federal Trade Commission has in protecting consumers. So we look forward to your testimony. Again, thanks for being here before the committee. And with that, unless any other members on our side want the remainder of my time, I would be happy to yield back.
Seeing none, the gentleman yields back the balance of his time. The chair now recognizes the gentleman from New Jersey, the ranking member of the full committee, for 5 minutes for an opening statement.
Thank you, Mr. Chairman. Today's hearing focuses on the important work of the Federal Trade Commission. I want to congratulate and welcome the new commissioners, Chairman Simons, Commissioners Phillips, Chopra, and Slaughter, and welcome back Commissioner Olhausen, I guess, I'm pronouncing it right. The FTC plays a critical role in protecting consumers nationwide. It has a dual mission to prevent anti-competitive business practices and protect consumers from unfair or deceptive actions. It's an enormous endeavor covering many industries and issues. It works to stop anti-competitive business practices that are likely to lead to higher prices and lower quality of goods and services, and at the same time, it works to protect consumers from false advertising, annoying telemarketing, data throttling, and other forms of fraud. While the FTC has had successes, such as its case against Volkswagen, in which it obtained $11 billion in compensation for consumers who purchased clean diesel cars that turned out not to be clean, the Commission should be doing more, in my opinion. But in order to do more in support of consumers, the FTC needs the support and legislative authorizations from Congress. Unfortunately, instead of working with the FTC, this committee just 2 years ago sought to further reduce the already limited authorities of the FTC, and I'm hopeful we'll not see that effort again. The FTC is a relatively small agency, especially given the breadth of its mission. In the area of data privacy and security, one of the more critical consumer protection issues today, FTC's entire division is only 45 full-time employees, and only 35 of those are attorneys who are able to bring enforcement actions. These actions are important since the Commission's rulemaking authorities are hindered by overly burdensome requirements that effectively nullify its ability to establish regulations for consumer privacy and data security. And even its enforcement authorities are limited. Most often, the FTC can only get an injunction stopping the unfair or deceptive acts for a first-time violation. The FTC cannot hit the offender where it hurts with a monetary penalty. A slap on the wrist with a promise not to do the bad act again often fails to be a sufficient deterrent to further bad action. Only if the company commits the same unscrupulous act again after promising in a consent decree that it would stop such conduct can the FTC seek fines. And that limitation on fining authority has allowed some companies to repeatedly take advantage of consumers without real consequences. Just a few months ago, we were here listening to Mark Zuckerberg apologize yet again for Facebook's failure to properly inform users of how their data would be shared. If the FTC was able to fine Facebook in 2011, the first time it found that Facebook failed to properly notify users, we may not have seen the Cambridge Analytica scandal. And to make matters worse, FTC has only 40 employees reviewing the hundreds of consent decrees that are in effect. Those employees cannot possibly know whether any one company is keeping the commitments it made in the consent decree. After all, Facebook was under a consent decree, and we saw what that wrist slapping did, nothing. And yes, Equifax was under a consent decree as well. So today's hearing is not on the breaches at Facebook or Equifax, but those breaches are good examples for exploring how the FTC could better fulfill its mission, and I look forward to hearing from the commissioners about their ideas for the future of the FTC, and hope we can discuss ways to support the FTC's dual mission and give it the tools that it needs. And I'd like to yield the time I have left to Ms. Matsui.
Thank you very much, Ranking Member Pallone. I've discussed the potential of blockchain applications in the subcommittee before. These include its possibility to facilitate spectrum sharing as next-generation broadband networks are deployed, maintain patient health records, and secure business transactions and communications between the Internet of Things networks. In its basic and essential element and function, blockchain is a decentralized ledger technology. But as a hype surrounding blockchain and its applications grow, how exactly blockchain is defined has become less clear. More fundamentally, there is no agreed-upon definition of blockchain. So I'm working on legislation that would direct the Department of Commerce to convene a working group of federal and industry stakeholders to develop a consensus-based, agreed-upon definition of blockchain. I believe a common definition of blockchain could greatly assist in its development and deployment. I invite all of you here on the panel and to work with me on this, as well as my colleagues here. And I hope that we can do this as quickly as possible. Thank you, and I yield back.
And I yield back, Mr. Chairman.
Thank you very much. The gentleman yields back the balance of his time, and that will conclude with member opening statements. The chair would like to remind members that pursuant to committee rules, all members' opening statements will be made part of the record. And again, I want to thank all of our witnesses for appearing before us today to take time to testify before the subcommittee. Today's witnesses will have the opportunity to give a 5-minute opening statement, followed by a round of questions from the members of the subcommittee. Chairman Simons, you are recognized for 5 minutes. If you just pull the mic up close and turn the button on, we'll glad to have you here today. Thank you.
Thank you so much. Chairman Latta, Ranking Member Schakowsky, and members of the subcommittee. I'm Joe Simons, and I'm the new chairman of the Federal Trade Commission. It's an honor to appear before you today, especially alongside my fellow commissioners. I'd also like to thank you for being so supportive of the FTC's resource needs over the years. As you've already said, the FTC is a highly productive and effective independent agency with a broad mission to protect consumers and to maintain competition. The FTC also has a long history of bipartisanship, and all of us here today are very committed to continuing that strong tradition. I'm going to focus my oral remarks today primarily on data security and privacy. Year after year, these two issues top the list of consumer protection priorities at the FTC. The Commission has challenged numerous privacy and security practices under Section 5 of the FTC Act. Our program in these areas, which includes enforcement, as well as consumer and business education, has been highly successful within the limits of our authority. But Section 5 is an imperfect tool. In my view, we do need more authority. I support data security legislation that would give us three things. One, the ability to seek civil penalties to effectively deter unlawful conduct. Two, jurisdiction over nonprofits and common carriers. And three, the authority to issue implementing rules under the Administrative Procedure Act. Make no mistake, however, under my leadership, privacy and data security will continue to be an enforcement priority, and the FTC will use every tool in its arsenal to address consumer harm to the extent we can. To date, the Commission has brought more than 60 cases alleging that companies failed to implement reasonable data security safeguards, as well as dozens of general privacy cases. We have aggressively pursued privacy and data security cases in myriad areas, including financial privacy, children's privacy, health privacy, and the Internet of Things. Recently, the European Union put into effect its General Data Protection Regulation. The FTC will be watching carefully and assessing the impact of this new regime to see what lessons we can learn that might be applicable to the U.S. In addition, GDPR, like its predecessor, imposes restrictions on the ability of companies to transfer consumer data from the EU to other jurisdictions, including the U.S. The EU-US Privacy Shield framework provides a mechanism that enables data to be legally transferred from Europe to the United States, and the FTC is committed to strenuously enforcing Privacy Shield. Finally, let me mention one additional item. The FTC has a tradition of self-critical examination, and in that vein, we recently announced our hearings on competition and consumer protection in the 21st century, and these will begin in the fall. This series of public hearings will explore whether we need to adjust our enforcement efforts, our priorities, and policies in light of changes in the marketplace and new thinking. Issues to discuss include whether we need to change the governing standard for antitrust enforcement, whether merger enforcement has been too lax, our remedial authority with respect to privacy and data security, and other issues. Discussion of these issues at the hearing, along with the public comments that will be collected throughout the hearings, will help inform our thinking. The FTC is committed to maximizing the use of its resources to enhance its effectiveness in protecting consumers and promoting competition, to anticipate and to respond to changes in the marketplace, and to meet current and future challenges. We look forward to continuing to work with the subcommittee and Congress, and I look forward to answering your questions. Thank you so much.
Thank you very much for your statement. And Commissioner Olhausen, you are recognized for 5 minutes.
Chairman Latta, Ranking Member Schakowsky, and members of the subcommittee, I'm pleased to appear before you today alongside my FTC colleagues. I've been a commissioner for 6 years and was honored to be named acting chairman in January 2017 and to serve in that capacity until May 2018. Having a leadership role at the FTC provides a unique insight into the vital protections the agency provides for the American consumer, and I'm proud of the work that we'll discuss in today's hearing. Although the FTC has many accomplishments, I will limit my remarks today to two areas: process reforms and competition enforcement. First, process reforms. In April 2017, I directed the FTC's Bureau of Consumer Protection to identify ways we could streamline our civil investigative demands, or CIDs, which are the agency's version of administrative subpoenas. This initiative was in part in response to concerns raised by members of Congress that FTC investigations often imposed undue burdens on legitimate companies. Now, of course, the FTC must remain an effective and aggressive protector of the American consumer. That is our primary mission. But we should also look for ways to be more efficient. These CID reforms have been in effect for a year, and I believe the agency has successfully navigated making the CID process friendlier to legitimate businesses without sacrificing our effectiveness. For example, one difficulty for small business is wading through pages of legalese. To lighten this burden, the FTC now includes a plain language description of the CID process in every CID we issue, and we've posted FAQs for small businesses on our website to help them. We are also being more selective about the time frame for requested documents or information. Obviously, the broader the time frame, the greater the burden on companies. It is now our policy, where appropriate, to limit the time frames in our CIDs to more recent years. And of course, when there is good cause, we will seek a broader range of documents and information, but that is now the exception, not the rule. These are just a handful of the ways that we've reformed our CID process so that we can continue to protect consumers without placing undue burdens on legitimate companies. And turning briefly to competition enforcement, I'd like to make just a few points. In fiscal year 2017, the FTC challenged 23 mergers and obtained remedies for consumers in 15 others, maintaining essentially the same merger enforcement pace during the beginning of this administration as it had during the previous one. And the brisk pace continues in fiscal year 2018, and the agency has already undertaken a number of merger challenges, including Tronox, Williamson, and Autobach, all of which are currently in litigation. During the 2017-2018 period, the Commission also stopped 3 mergers when the parties abandoned them after we sued. And in addition, Walgreens substantially restructured its proposed acquisition of Rite Aid due to Commission concerns. And I would like to highlight 2 merger cases that focus on important points about our competition mission. DraftKings FanDuel was a proposed merger of 2 internet platforms offering so-called daily fantasy sports contests, and the FTC sued to block the deal, finding that these 2 companies were the leading providers and that other forms of fantasy sports were inadequate substitutes. And importantly, the Commission rejected arguments that the technology was too nascent and fast-moving to be able to draw reliable conclusions. And in the face of the FTC's challenge, the companies ultimately abandoned their transaction. And the other case I'd like to briefly mention was CDK Automate, which involved 2 providers of specialized software used by auto dealers. Our challenge to the deal noted that the current levels of competition between the parties likely understated the competitive significance of the smaller firm. In effect, the larger firm was buying out this promising upstart before it could grow to become a much more serious competitive threat. And in the face of the FTC's challenge, the parties abandoned their deal. Both of these cases were big wins for U.S. consumers, but they also show how the Commission can use its existing authority to intervene in a factually grounded, economically nuanced way, even in fast-moving, high-technology markets. In addition to merger review, we've also brought a number of important conduct cases, including several challenging anti-competitive behavior by drug manufacturers. And finally, our Economic Liberty Task Force, which I launched last year, has helped to spotlight unnecessary or overbroad occupational licensing, which often disproportionately harms those near the bottom of the economic ladder and burdens our military families. So thank you for your time, and I look forward to your questions.
Well, and thank you very much for your testimony today. And Commissioner Phillips, you're recognized for 5 minutes.
Thank you. Chairman Latta, Ranking Member Schakowsky, distinguished members of the subcommittee, thank you all for the opportunity to be before you today. I'm honored to be here with my fellow commissioners, and from our testimony, I hope you see the important work that the FTC and its staff do every day on behalf of American consumers. As you all know, our economy is increasingly globalized, digitized, and connected. These changes generate incredible opportunity, but they also pose new problems for consumers, such as traditional scams that now thrive online, and new internet-enabled frauds. And they also raise important enforcement challenges, like the enhanced ability of scammers to act anonymously or to move their ill-gotten gains abroad and outside of our jurisdiction. They also create roadblocks to international law enforcement cooperation. Congress has been an essential ally in this fight. In 2006, it passed the U.S. Safe Web Act. Safe Web allows the FTC to share evidence with and provide investigative assistance to foreign authorities in cases involving spam, spyware, privacy violations, and data breach. It also confirms our authority to challenge foreign-based frauds that harm U.S. consumers or involve material conduct in the United States. Using Safe Web, the FTC has worked with authorities abroad to stop illegal conduct and secure millions in judgments from fraudsters and sometimes even criminal convictions. The FTC uses Safe Web authority in important international privacy cases. We collaborated with Canadian and Australian privacy authorities on the massive data breach of the Toronto-based adult dating website ashleymadison.com. And we worked again with Canadian authorities on FTC's first children's privacy and security case involving connected toys, a settlement with electronic toy manufacturer VTech Electronics under the Children's Online Privacy Protection Act. In total, the FTC has responded to more than 125 Safe Web information sharing requests from 30 foreign enforcement agencies. We have issued more than 110 civil investigative demands in more than 50 investigations on behalf of foreign agencies, civil and criminal. The FTC has collected millions of dollars in restitution for injured consumers, both foreign and domestic. Safe Web helps protect Americans by policing and instilling confidence in the digital economy. But it sunsets in 2020. The Commission respectfully requests that Congress reauthorize this authority and eliminate the sunset provision. Our international efforts support American business leadership in the global digital economy by enabling transatlantic data flows and protecting privacy. As Chairman Latta rightly highlighted in his remarks, the FTC works with the Department of Commerce on 3 key cross-border data transfer programs, including the EU-US Privacy Shield. Privacy Shield provides a legal mechanism for companies to transfer personal data from the EU to the US with strong privacy protections, and the FTC enforces these companies' Privacy Shield promises under Section 5 of our organic statute. We are committed to the success of Privacy Shield and the other cross-border data transfer mechanisms. We have brought nearly 50 actions to enforce them, including 4 under the new Privacy Shield, 1 announced just 2 weeks ago. Privacy Shield is an important mechanism for encouraging commerce and protecting privacy. Enforcement of it is and will remain a priority for the agency. Thank you for your time and attention, and I look forward to answering any questions that you have.
Again, thank you very much for your testimony, and Commissioner Chopra, you're recognized for 5 minutes.
Chairman Latta, Ranking Member Schakowsky, and members of the subcommittee, thank you for the opportunity to testify and discuss data security and privacy. According to survey data, 91% of adults believe they have lost control about how companies are collecting and using their personal information. News reports of data breaches and disclosure of sensitive data have become routine. On the dark web, stolen credit card and social security numbers and social media profiles can be bought and sold. For many Americans, the situation seems hopeless and they feel powerless. And Washington cannot be sitting on the sidelines. We must confront the risks to our economy, our society, and national security of inadequate data security and privacy. And the cost of inaction is growing. According to an industry study, over 15 million Americans were a victim of identity theft in some form in 2016, leading to $16 billion of losses. The majority of these Americans had their records accessed in a data breach in the years prior to their identity theft. When we talk about data security in Washington, we typically focus on protecting power grids, payment networks, and other critical infrastructure to avoid a crippling attack. But we also know that the infiltration of commercial holdings of consumer data can also cause chaos. Large-scale breaches of unencrypted data are increasing these risks, and we must do more to secure personal data from falling into the wrong hands. Chairman Simons is right. The FTC cracks down on illegal practices whenever we can. But I think our existing toolkit won't do the trick. In too many situations, our resolution is to tell a law-breaking company to simply stop breaking the law. To truly make a difference when it comes to data protection, we need the ability to deter misconduct through financial penalties and sensible safeguards that can evolve with the marketplace. And when it comes to privacy, the United States should lead. New privacy protections from Europe and California are advancing, but we shouldn't feel we have to simply copy and paste. We should be leading. I believe privacy and competition can go hand in hand, especially when consumers can access their data in portable and interoperable formats. We can increase privacy protections without crowning corporate royalty. We don't need to start from scratch either. Congress can build upon existing privacy laws, such as the Children's Online Privacy Protection Act. 20 years ago, incumbents warned that this bipartisan effort to protect children online would end in utter disaster for our information economy, and boy, were they wrong. COPPA has common sense ideas. Data collected for one purpose shouldn't be used for another purpose without your permission. You should have the ability to review the information collected about you. Companies should be upfront and honest about who they're sharing your data with. And strong protection should be backed by an enforcement regime that can hold companies and their operators accountable. Over the past decade, the FTC has produced scores of studies and reports, but now it is time for Congress to act. I'm confident that if Congress entrusts the Federal Trade Commission with the authority and resources to do more to protect families and businesses, we will deploy them efficiently and effectively while continuing to promote a dynamic digital economy that truly benefits all of us. Thank you.
And thank you very much for your testimony. And Commissioner Slaughter, you're recognized for 5 minutes for your opening statement.
Thank you, Chairman Latta, Ranking Member Schakowsky, and members of the subcommittee. Thank you for inviting all of us here today. I would like to use my oral remarks to highlight the critical work the Commission does to protect American consumers from fraud and from illegal robocalls. I also want to draw attention to the resource challenges of the Commission. Although it sometimes grabs fewer headlines, fighting fraud is a central part of the FTC's consumer protection mission. The Commission routinely tracks down and stops some of the worst scams, often targeting consumers who can least afford to lose money, including the elderly, members of the military, students burdened by debt, and small businesses. The FTC takes the lead on important initiatives to shut down fraudsters and joins with our federal, state, and international law enforcement partners. Some recent examples of these initiatives include Operation Tech Trap, a crackdown on tech support scams. Another example was Operation Game of Loans, where we led the first federal and state coordinated action targeting 36 student loan debt relief scams. And just last month, we announced Operation Main Street, an effort to stop small business scams. The agency has also been at the forefront of addressing deceptive money-making frauds involving cryptocurrencies, bringing enforcement action and hosting a workshop to explore how scammers are exploiting public interest in cryptocurrency and how to empower and protect consumers against the growing threat of exploitation. This is an area we must continue to monitor closely, including working with stakeholders who don't traditionally engage with the FTC. On robocalls, few things unite Americans more than their outrage over illegal robocalls, and I include myself among the outraged. The FTC uses every tool at its disposal to stop illegal calls. We've brought 137 cases targeting over 800 individuals and companies responsible for billions of illegal calls to U.S. consumers, and we've collected over $121 million in judgments. But as anyone with a phone knows, the problem persists. While our aggressive law enforcement efforts will continue, we know that the explosion in illegal calls stems from technological developments in the calling landscape. Law violators can now place endless streams of calls for a fraction of a cent, and too often the criminals behind some of the worst calling scams are located abroad, beyond the immediate reach of a civil law enforcement agency. Technological problems need technological solutions. The FTC has been a leader in pushing industry to develop those solutions, helping to spur providers and third parties into offering call blocking options. However, the best long-term solution is to empower and expect providers to deploy solutions at the network level that will reach every consumer. Effective blocking tools to stop spam should be available to all consumers using every kind of phone system, and carriers should have both the right and the responsibility to keep their systems clear of unwanted calls. The FTC is currently limited in its ability to address failures on the part of providers as a result of the common carrier exemption to our jurisdiction. Some carriers know or have every reason to know that they are passing along illegal or even fraudulent calls, but they are beyond our reach. Speaking as a consumer as well as an enforcement official, I share the public outrage at Robo Calls, and I am eager to work with Congress to empower the FTC to do even more to combat this profound nuisance. Finally, I'd like to say a word about our resources. The FTC works tirelessly to protect consumers and advance competition in an increasingly technical, digital, and sophisticated marketplace. Consumers rightly look to the FTC to address evolving challenges, and one of my top priorities is to make sure that we meet those expectations successfully. We have excellent, expert, experienced staff who want nothing more than to hold lawbreakers accountable. We leverage them as effectively as possible. But we have more cases to bring every day. Those cases have become more complex both legally and technologically, and they involve defendants with deep pockets and armies of attorneys. Our budget has not kept pace with these developments. To wit, we had more full-time employees in the Reagan administration than we do today. It is critical that the FTC have sufficient resources to support its work, particularly as demands for enforcement in so many complex areas continue to grow. In addition to sufficient resources, as several of my colleagues have noted, sufficient authority is critical for the FTC to continue to meet the demands of the 21st century marketplace. Repeal of the common carrier exemption, APA rulemaking authority, and related civil penalty authority would each go a long way to help the FTC better meet today's challenges as well as tomorrow's. Thank you, and I look forward to taking your questions.
Well, thank you very much for your testimony today, and I again thank all the commissioners for being with us today. And I'll start the questioning with 5 minutes. And Chairman Simons, if I could start with you. You bring very strong antitrust credentials to the FTC, previously serving as head of the Bureau of Competition. One of the priority issues for the subcommittee is the consumer protection jurisdiction enforcement activities of the FTC. And I noted in your opening remarks, you talked about especially enforcement on IoT, which is, I've sponsored legislation with the gentleman from Vermont and on the Internet of Things, but we also, in the last Congress, had the working group. So the Internet of Things is something that we're very concerned about. With recent headlines highlighting the open investigations of Equifax and Facebook, which I know you can't comment on, and the 11th Circuit recent decision highlighting the unenforceable order of LabMD data security case, how would you describe your general approach to consumer protection enforcement?
Our mantra is vigorous enforcement, Chairman. So that's what we're all about. We're about protecting the consumer and vigorous enforcement. In addition, we are very active in terms of not only trying to create a disincentive for the bad guys to do the wrong thing, but in addition to educate consumers and small businesses and businesses generally to make sure they do the right thing. So very, very enforcement oriented, very vigorous, and across the board. One of the things you probably noticed from the remarks of the commissioners was that it was spread out in terms of different subject matters, and that was not by accident. So we are aggressive across the board, whether it's data security, privacy, all kinds of different fraud, across the board.
Okay, well, let me follow up. You mentioned on the civil penalty authority, the FTC does not have the civil penalty authority today to enforce initial violations of the safeguards rule that covers companies like Equifax, Would you support civil penalty authority to enforce the safeguards rule?
Yes.
Okay, thank you. Would you like to follow up on that?
Yeah, sure. So one of the problems that we have is we're able to show in these cases that there is sufficient harm to show a violation under the statute. But in terms of our monetary remedial authority, and showing damage from any particular breach and tracing it to that specific breach is very difficult. So it really hinders our ability to seek a significant monetary penalty or monetary relief and to create a sufficient deterrence so that conduct doesn't occur in the future.
Let me follow up with another question to you. Interesting, I was listening when you were talking about your announcement of the series of public hearings this year on the 21st century challenges to the economy. And I also commend you and the Commission for taking a thoughtful approach to examining whether the current legal, economic, and technological predicates warrants adjustment to competition and consumer protection policy. Would you share your goals for the hearing, including efforts to update the agency's research and policy function or to set the foundation for enforcement actions and policy agenda setting?
Yeah, so we're conducting these hearings with a broad range of participants from all over the spectrum of thoughts and ideas. And so we're going in with an open mind, and we're not expecting any particular outcome. But potential outcomes would be things that would involve, for example, amending our horizontal merger guidelines, drafting potentially new vertical merger guidelines. We might also, we're going to also look at privacy and data security, and maybe we'll come out with strong suggestions there as how to move forward, maybe along the lines of Commissioner Chopra suggestions a minute ago. So it's really quite wide open. The last time that hearings of this nature were conducted, there were substantial action items coming out of those hearings. This was done by then Chairman Robert Potofsky, and one of the main things that came out of that was amendments to the merger guidelines relating to efficiencies. There was also a lot of work done on the intellectual property area, and so our goal is to try to be as effective as in these hearings as Chairman Potofsky was in his hearings.
Well, thank you very much. And my time is about to expire, so I'm going to yield back and recognize the gentlelady from Illinois, the ranking member of the subcommittee, for 5 minutes.
Thank you. Let me just say, as a probably long-term, I've been a long-term consumer advocate since I was a very young woman, so I have a special place in my heart for the Federal Trade Commission and want to ask about your authorities. Most agencies issue regulations under the Administrative Procedures Act, which sets out notice and public comment procedures for issuing regulations. But unless granted APA rulemaking authority for specific issues by Congress, the FTC issues rules under a different law, which provides more burdensome procedures and makes it more difficult for the Commission to issue rules. So I wanted to ask you, Mr. Chairman, do you agree that the FTC currently is limited? And for example, an example I think you gave in a meeting, could not write rules like the open internet rules written by the FCC?
Yeah, so I generally do agree with your characterization of our rulemaking authority. So our general rulemaking authority is under the Magnuson-Moss Act, and it is considerably more burdensome than the Administrative Procedure Act. So I agree with that completely. In terms of your question about the net neutrality rule, I don't think that we could adopt exactly the same rule. And if we were to try to do it under Magnuson-Moss, like you said, it would be pretty time-consuming. However, what we normally do is we bring enforcement actions, and our sense is that those actually accomplish pretty much the same thing.
I wanted to ask about that. It says, without effective rulemaking authority, the FCC has focused on its efforts on law enforcement, and we've heard a number of really positive examples. So but it seems to me that the enforcement-only approach is not as effective as when legal standards are supported by agency rulemaking.
I think a mix, depending on the circumstance, of rulemaking and enforcement it could be optimal.
So, you know, this issue has come up often in this committee's discussion of data breach legislation. Yes. Previous commissions have supported APA rulemaking authority for data security and breach notification. Ranking Member Pallone and I have introduced a bill, I mentioned it in my opening statement, 3896, a Secure and Protect Americans Data Act, that would require companies to have reasonable data security and notify consumers in a reasonable time when breaches occur. So to the whole panel, our bill would give the FTC authority to write rules on data security and breach notification using APA rulemaking. And I would just like to go down the row and see if you would support that.
Yeah, without commenting on the specifics of your bill, I certainly support in concept what you're suggesting.
Thank you.
As I have previously supported data security and breach notification legislation, I would also support it without supporting particular details.
You haven't, right. Thank you.
I too support legislation. Congresswoman, I have not yet formed an opinion with respect to particular rulemakings. One of the things I look forward to in our upcoming hearings that the chairman has announced is the fact that we're going to be doing a careful study of the remedies available to us, and I look forward to learning from those.
Yes, and I would add that rules, the development of rules is a much more participatory process than individual enforcement actions, and it also gives clear notice to the marketplace rather than being surprised, and I think it would be a good idea.
Good point, yes.
Yes, like my colleagues, I haven't studied your particular bill, but as you describe it, it's something that I would very much support.
Let me just say the word partner came up a good deal in various testimonies, both on the committee and on the panel, and I hope that we can use that approach. I want to see if Chairman Simons, if the FTC had APA rulemaking authority now, would you direct staff to begin the rulemaking process for data security and breach notification?
Sure, yes.
Okay. Even though FTC's current rulemaking procedures are burdensome, couldn't the FTC issue an advanced notice of proposed rulemaking rulemaking or a notice of inquiry to collect data and get the process started now?
We could certainly start a rulemaking under Mag Moss. It would just, be time-consuming and really resource-intensive, and so there's an issue about whether we want to start that, not knowing whether we could finish it under.
If I could just have a couple more seconds. We've had these high-profile hearings from Equifax, Zuckerberg was sitting in that chair, as the chairman mentioned, and yet we really have not moved forward, I think, in doing something about these data breaches and the mistakes that have been made. Really look forward to working with you and meeting with all of you. Thank you.
Thank you very much, Gentlelady's time has expired, and the chair now recognizes the gentleman from Oregon, the chairman of the full committee, for 5 minutes.
Thank you, Mr. Chairman, and I want to thank you for your leadership in this area on data breach, data security, and all. And I think you've had, 4 roundtables, including one yesterday, I think, with how many participants? 38? Yeah, we know this is pretty complicated. If there were an easy answer, we'd all do it. Because, I think my colleague from Illinois, Ms. Schakowsky, said, she worries about her data being breached by Equifax. I don't think you have to worry. I think it is. I think the worry part's gone. And that's the tragedy of it all, is we don't have control over our data. And we have laws on the books in some cases. Companies have trust obligations in other cases, and they don't have the security in most cases. And so it is something we're all concerned about as consumers and as policymakers and enforcers. And so it's something this committee's very concerned about. And as I say, we've been trying to find if there's an eye in that needle to thread legislation to get to data breach, data notification, hold people accountable, and we're closing in on it. And like others on the committee, I think we're all consumers. and I care deeply about putting the consumer first. That's been part of my mantra as chairman of the committee, because if you do that, you have competitive markets, you have innovation, you have price competition, you have choice, and consumers benefit. And Ms. Slaughter, your comment about robocalls, I'm fully in agreement with. I remember when pop-up ads were a nuisance. I was tongue-in-cheek suggested death penalty for those people because you couldn't do anything on your computer. You had bazillions of these pop-up ads. We had a hearing on robocalls, and the private sector, the technology sector, is being pretty inventive. And one of the witnesses has an app that they market. I won't promote a particular one, but it actually figures out to answer the call and then pretends to be real and keeps the caller on the line for half an hour. I love that kind of thing. Run their bill up, drive them crazy. And so, you know, we got a lot of young kids out there with brilliant minds that can develop these apps and help us in this endeavor. But one of the big challenges, of course, is a lot of this stuff's overseas and hard to, even for you or for us or anybody, get their hands around. Or boy, we'd have our hands around their necks. So, Chairman Simons, what role do you believe antitrust plays with respect to consumer protection? Give us your thoughts on that as chairman. Okay, yeah.
It's similar, Mr. Chairman, to what you just suggested. So the more competition, the more likely it is the consumer is going to be benefited. And what goes hand in hand is that competition and consumer protection. Consumer protection in terms of good information in the marketplace, non-deceptive information in the marketplace, an efficient advertising market. Those are things that make firms compete stronger, and it drives competition. So we want to have those two things. We want to have vigorous competition. We want to make sure that firms are not behaving anti-competitively, and at the same time, we want to make sure that consumers have the information that is necessary for them to make the right decisions and right choices in the marketplace.
And with this emerging digital economy that's, well, fully underway, but, you know, it's emerging every day, there's something new. And you see we have legacy rules, we have industries that are built upon those, and then you have a new entrant into the market, and then you have consolidation and mergers and people trying to compete. So what questions are you most focused on regarding the changing digital nature of the U.S. economy during your public hearings?
We're focused on a very broad range of things. Everything from whether the consumer welfare standard, which has been the kind of consensus standard for the last 20 or 30 years, whether that needs to be changed or not, whether the way we have done merger analysis in the past 20 or 30 years has been appropriate, whether that's been too lax. We're also focused on the consumer protection side, particularly in terms of privacy and data security. In terms of one of the things that, as I mentioned in my oral remarks, that we're very focused on is a potential trade-off between privacy on the one hand and data security on the one hand and competition on the other hand. Right. We're a little nervous that if you do privacy in the wrong way, have it go too far in one direction, that you might end up reducing competition. You might create a situation in which you entrench the large tech platforms, for example. You make it very difficult because the advertising market becomes potentially much less efficient, you make it much more difficult for new entrants and smaller firms to get the attention of the consumers that they're trying to reach. In fact, one of the things that I saw very recently after the effective date of the GDPR was an article in the Wall Street Journal that reported that they could already see that advertising was moving to the Google platform over in Europe. And so that's something we're very conscious of and we want to be very careful about. And when Congress thinks about these things in legislation, this is something that my recommendation would be you think carefully about to strike the right balance.
That, and I know I'm over, but that's exactly the conundrum we're in, is finding that right balance, because you have just a couple of platforms that dominate in the online advertising world today. So you want that competition, but you don't want to do something that actually enhances their dominance, if you will. So I appreciate that, and I yield back.
Thank you very much. The gentleman yields back. The chair now recognizes the gentleman from New Jersey, the ranking member of the full committee, for 5 minutes.
Thank you, Mr. Chairman. Much of the FTC's consumer protection enforcement actions are brought under Section 5 of the FTC Act, which prohibits unfair and deceptive acts or practices. and the remedies available for these cases are limited. The FTC can only seek an injunction and conditions, which most often come in consent decrees. It can't seek civil penalties for first violations. And I know, Chairman Simmons, you mentioned already today that you support giving the FTC authority to seek civil penalties for first violations when companies fail to maintain reasonable data security. How would that tool help the FTC's efforts to protect consumers from data breaches?
Thank you, Congressman. So what that would do is that it would enable us to impose a sufficient monetary penalty that would incentivize companies to better protect data. As you've said, and as others have said, if what is going on in terms of our enforcement authority is that we can only get an injunction that just says, sin no more, then that's much less of a deterrent than if we could get monetary penalties that would actually, cause the business to think through how it's conducting its business and what it's doing in terms of security and privacy.
And now, I know that, to clarify, when the FTC does have authority to seek civil penalties, it's still up to the FTC to decide whether to even ask for those penalties and how much those penalties should be, correct?
I'm sorry, could you repeat that?
When the FTC does have authority to seek civil penalties, it's still up to you to decide whether to even ask for those penalties and how much those penalties should be, correct?
Sure, yes.
Okay. So do you think that civil penalty authority would be beneficial for FTC's privacy cases as well?
That's something I think we should explore. I don't have a view on that yet. Maybe something will come out of the hearings that we're going to conduct in the fall that will inform our views.
I appreciate you having those hearings in the fall, too. I think it's great that you're doing that. What about the other Section 5 violations? Would you support legislation giving the FTC civil penalty authority for other enforcement actions?
So other enforcement actions, I think, are a little different in the sense, like fraud, for example. Even though we're going under our Section 5 authority that provides for injunctive relief, as part what's ancillary to injunctive relief is the ability to get restitution and disgorgement, and those can serve as significant deterrent effects. So, with respect to fraud, that's something that where our existing authority probably is sufficient, but with data security and privacy, it just becomes very hard to prove the extent of damage to any.
But I'm thinking of like Robo Calls, which I know we discussed. You see that as different? Like if,
Well, we have a rule, and so we can't get civil penalties for violations of robocall, the robocall, the telemarketing sales rule.
Congressman, if under our statute, we're able to ask a court for civil penalties in the case where there's a rule on the books or when there's a violation of an order, generally speaking. So when we do have a rule on the books, it is easier, even on the first offense, we are able to ask a court for civil penalty.
Yeah,
and that's one of the reasons why rulemaking also could increase deterrence as well.
All right. Well, now let me just say one more thing. I wanted to ask you about the Uber settlement. FTC recently announced an expanded settlement with Uber, and while the FTC was in the process of negotiating a settlement with Uber, making deceptive privacy and data security claims, FTC learned that Uber failed to disclose another significant breach of the customer's data, which Commissioner Olhausen called strikingly similar. So just quickly, I only got less than a minute. Chairman Simmons, the expanded settlement with Uber includes some additional requirements, but does not include civil penalties. Why couldn't the FTC seek civil penalties related to the second data breach?
We would have to show that that was a violation of a pre-existing order.
Okay.
There was no pre-existing order.
But FTC found that Uber twice committed misconduct, but still couldn't impose fines? Maybe I'll go back to Commissioner Chopra. Do you think this situation is sufficient to stop repeat offenders in the case of Uber?
Well, my understanding of the Uber resolution was that the order was modified based on conduct that was not a direct violation of the original order. And this is what I'm talking about. Our limitations on obtaining civil penalties or when there's a rule violation or a violation of an order itself. So I, of course, and I think all of us want to make sure that FTC orders are followed, and if they are not followed, we will seek all appropriate relief we should. But the question you're raising about whether on a first offense there should be penalties, I think that in order to deter misconduct, we need to consider when it's appropriate that even on a first offense, the lack of penalties may not serve as adequate deterrence.
All right. Thanks so much. Thank you, Mr. Chairman.
Thank you. The gentleman's time has expired, and the chair now recognizes the vice chairman of the subcommittee, the gentleman from Illinois, for 5 minutes.
Well, thank you, Chairman, for yielding, and I thank you all for being here today and taking some time and everything you do for the country. Commissioner Olhausen, the Commission's website states that the FTC protects consumers by stopping unfair, deceptive, or fraudulent practices in the marketplace. I want to ask you a rudimentary and kind of direct question. Do you think a private company should ever be compelled to provide inaccurate information to consumers that's deceptive or could impact the marketplace?
I would certainly be concerned about any company providing inaccurate information to consumers, whether they did it voluntarily or were required to do so.
Okay. Commissioner Olhausen, cryptocurrency scams have been fertile ground for scammers since the value of Bitcoin and other tokens skyrocketed in value at the end of 2017, bringing with it rising interest in raising capital for startups via initial coin offerings. Last Congress, I worked with Representative Cardenas to pass a resolution, 835, through the House, highlighting the importance of improving consumer access to financial technology tools. Besides the recent workshop on cryptocurrency scams, what more is the FTC doing to target things like deceptive investment opportunities and bogus mining operations?
So we actually have brought 2 cases involving cryptocurrency, 2 enforcement actions where there were deceptive representations to consumers. And we also have a long history of bringing at different times enforcement actions against deceptive promises about precious metals.
And is that getting enough public attention, do you think, or should it get more, and how?
We're always happy to get more public attention and interested in ways to
Sometimes you have to compete for bandwidth in the media. The goal of the U.S., and I'll ask each of you this question, the goal of the EU-U.S. Privacy Shield is to protect personal data and enable the flow of transatlantic data. Without this framework, companies on both sides of the Atlantic would face grave uncertainty and serious limitations on their ability to conduct business overseas. So for each of you, yes or no, do you pledge support for Privacy Shield and commitment to enforce the framework?
Absolutely.
Yes.
Absolutely.
Yes.
Yes.
Good. It's easy. And Chairman Simmons, the calendar years 2015 and 17 and the first quarter of 2018 all broke records for merger and acquisition activity. In the first quarter of 2018, for instance, the merger activity increased 67% year over year. Research has found that economic concentration has increased in many or most economic sectors. At the same time, researchers have found that entrepreneurs are not starting new businesses at a rate sufficient to overcome business closings. Do you think that increasing concentration is cause for concern or evidence of declining competition in the U.S. economy?
Thank you, Congressman. So that is one of the main focuses of the hearings that we're going to have in the fall. Precisely that concern is one of the things that we want to get testimony about and take comments on.
You'll be in a better position, you think, to comment after all that?
Yeah, and in other words, it's an important focus of the hearings because based on what we see in terms of the economic literature and otherwise, there's enough out there to be concerned that those things are really problematic.
And do you see any correlation between rising concentration and declining rates of new firm formation?
Not specifically. I mean, some of the material that you're probably citing relates to broad industry categories. So, for example, you might have, and the categories could be national. And so, if what you have in the marketplace is you have chains who are becoming more pervasive and displacing local companies. The local concentration might not be changing at all, but the national concentration is, and for antitrust purposes, in those types of markets, it would probably be the local concentration that you'd want to worry about. So there might be some other issues going on, but that's part of our job or our intent is to kind of figure that out.
And thank you. And last question for you. Two companies, Google and Apple, together dominate the market for mobile operating systems, accounting for 99% of the market for smartphones in the United States. And you have seen the news, I'm sure, this morning that the EU is set to fine Google $5 billion antitrust for the way it bundles its apps on Android smartphones and tablets. The question is, what, if any, competitive discipline exists in such a highly concentrated market?
So there's the two of them, so they compete pretty heavily against each other. So that's one level of competition. But I have to agree with you; it's concentrated. So it's not like commodities in the Midwest or whatever. Which are obviously very fragmented. This is a concentrated industry, and this is an industry, as I've said before, what we do in the antitrust world is most of the problematic conduct occurs where firms are big and have market power, and that's where we look, and so this is one of the places we would focus on.
Okay, thank you. I yield back.
Thank you very much, gentlemen. Time has expired, and the chair now recognizes the gentleman from Vermont for 5 minutes.
Thank you, Mr. Chairman. I've got 5 minutes, so I want to go through this quickly. First, I want to say congratulations to each of you. I've read all your resumes. You people are smart. And in addition to that, you've got a record of public service, and it demonstrates you're not only smart, but you actually want to use your talent for the public good. And I just want to say to you that I think serving on the FTC at this time is incredibly important. I think a lot of working Americans are being squeezed at one end because wages aren't going up, and at the other end because what Mr. Kinzinger was talking about, incredible pricing power as a result of anti-competitive practices, and more, that is so essential that you stand up for the American consumer. So you're 3-2, but I hope you're 5-0 in asserting the need to have a very strong FTC to help working Americans, so thank you. I want to talk about a couple of things. One, in April, a bipartisan group of my colleagues, including on this subcommittee, Congressman Jeff Duncan and I wrote to you about the technological changes taking place in mobile commerce. And we think it's important for the FTC and the Department of Justice to be vigilant to make sure that incumbent businesses with existing payment technologies don't use that market position to block innovations and developments by potential competitors. And I appreciated very much the Commission's response to our letter, where you indicated that you'd look closely at the payment standards setting process and your assurance that the Commission will take appropriate action against any act or practice in the mobile payments marketplace that violates any of the statutes that you enforce. And I'd like to submit for the record, if I could, Mr. Chairman, our letter, these letters. I want to ask you, Chairman Simons, with our mutual goal of detecting and remedying any practice that may harm competition and consumers, can you share what you have done to date on the issues we raised in our letter to protect competition and innovation, and quickly if you can?
Yeah, sure. So, standard setting, which is what you're describing, is a really important thing in our economy. It can be useful for great numbers of efficiencies. As you can tell, the payment system itself is very interoperable. There's a bunch of different players in it, and they have to interoperate. It's all the banks, the credit card companies, and all the merchants, of course. So it's really important that function, but it's also possible that those types of organizations can be used for anti-competitive purposes. And we've had cases involving anti-competitive activity and standard setting bodies, and so we're focused on that.
Thank you. Let me go on to my next question. And I was pleased to see just yesterday that the FTC issued a statement to Health and Human Services in response to the HHS request for public comment on lowering drug prices and out-of-pocket cost, which laid out the Commission's concerns with pharma companies abusing the REMS program to prevent generic competition. The Commission comments really captured the issue perfectly, and I can read it. The REMS program can protect the public from farm abuse, but they can also be misused to disrupt competition and innovation. And you go on to say the FTC supports regulatory and legislative actions aimed at correcting the misuse of REMS programs. I believe that's exactly right, and I want to thank you for that. Chairman Simons, as we continue to consider the Fast Generics Act and the CREATES Act, how can Congress deter the current abuses and delays by brand manufacturers, instead motivate them to provide generics with access to samples in a timely way?
So, without giving a view on the precise specifications in the Act and the legislation you're describing, we're very supportive of this issue.
Okay, let me interrupt you because I just have a few seconds left.
Sorry.
But thank you, and I appreciated the FTC letter. Another issue that's come to my attention is that web browsers are considering the changes to the user interface that consumers see on their screens. Specifically, in the coming months, consumers who are already wrestling with how best to protect themselves will potentially be provided with less information about the security of the website they are using at any given time. We should be working together to provide consumers with that information. Is this potential change to consumers' web browsing experience something that Commission is aware of? That's the security label at the top. If so, I'd ask the Commission to keep consumers in this committee updated on the impact of that potential change. And I'm out of time, so it ends up as a statement, not a question. But again, Mr. Chairman, I want to thank you. I think your institution, your agency is so vital. I hope you find a way, better than sometimes we find the way, to work together to get to an outcome that'll be durable and helpful to the American people. So thank you.
Thank you very much. The gentleman's time has expired, and the chair now recognizes the gentleman from Texas, the chairman of the Health Subcommittee of the full committee, for 5 minutes.
Thank you, Mr. Chairman, and I appreciate our commissioners being here. This is always a good day when we have all of our commissioners in front of the committee. Chairman Simmons, you began your testimony stating that Section 5 is an imperfect tool, and granted it is, but it's the tool that we have. Still, after years of studying the LabMD case, and I realize that most of you were not even born when that case started, and I also understand that although there was a recent 11th Circuit decision, I'm certain it's not settled yet, but here in the aftermath of that, a business that arguably had a good business plan and was competently run, but because of a breach that occurred in technology that was really poorly understood years ago, now this business is no more, and the people that were involved have obviously suffered significant harm. And really, my question is this a learning process as we look back? And I know you can't talk about the specifics of the case, because I do understand that it's still in litigation, but it's been a hard one as I've watched for the last 10, 15 years in Congress. I practiced medicine before then, so I certainly understand that, yeah, you could have somebody in your front office do something on a computer that puts some data at risk, but in the absence of harm, to do this much violence to the business plan and the business model seems a little bit over the top. I just wondered if is this an ongoing process that you're learning about this imperfect tool?
Sure. I mean, one of the things the FTC does is it has a good history of engaging in self-critical examination. So, first of all, let me say that, of course, we never intentionally try to put legitimate businesses out of business. We try to get them to comply with the law and not drive them from the market. That's bad for competition, which is the other side of our mission. So we really don't want to do that. And then the other thing I will say is that we do engage in self-critical examination, even outside these public hearings. We do it internally. Sure. And so one of the things that we've got going on is a task force on how we do our orders. And so that's relevant to the LabMD decision.
It's reassuring to know that. Again, that history is history, and what has happened, and none of us can undo that. But I am grateful to hear that. Let me ask a question about robocalls, because, man, they are a nuisance. And in our house, we have 3 cell phones, and they can all ring simultaneously with the same identifying number from a town called Mahia, Texas, which is a small little town between Waco and Dallas. I don't know if it really did originate from there. And they're all selling, well, there was a hailstorm in your community, and we're in the neighborhood, and we thought we'd come by and check your roof for you. But 3 simultaneous calls come at the exact same time. It just doesn't seem reasonable that that's one person doing that. Is there a recourse for the consumer at this point? I know we've passed do not call laws. In this committee, we've passed anti-spoofing laws. Is there a recourse for the consumer? Should I have them call your 800 number? What is the next step?
So one of the things, I'm sorry, was that directed to?
Well, anyone can answer. Okay. Ms. Slaughter brought it up, but Chairman, you're welcome to answer as well.
Well, I don't want to hog the attention, so if anyone else would like to answer, please go ahead.
Thank you for the question. I think we probably are all on the same page about this, so you could hear a similar answer from any of us. It is enormously frustrating for consumers. It is just endlessly frustrating, and I can't tell you sitting here whether those 3 calls originated really from Texas or not. The challenge for us that I outlined a little bit in my testimony is that many of the people orchestrating these calls and orchestrating these schemes are overseas and hide behind spoofing technology.
So the next step for the consumer that gets these calls, what should we tell them?
So the best, right now, the technological solutions that the FTC has helped push into the marketplace can be among the most helpful, that identify calls as fake or robocalls when they come into your phone and block them. Chairman Walden talked about one such example. But I think looking at larger scale solutions that can be implemented across network levels is an important thing.
Okay. And it's a longer discussion. I am going to submit some questions for the record, but the issue of consolidation in the healthcare industry. And when I was in practice back in the late 80s, I worried that there was going to be a single payer healthcare system and it was going to be called Aetna. And now the corner drugstore is buying Aetna. So it is a cause of some concern for those of us who sit on this committee. We've had hearings on it. I will have some specific questions for you on that, and I'd appreciate your attention to that. Thank you.
Thank you very much. The gentleman's time has expired, and the chair now recognizes the gentleman from Massachusetts for 5 minutes.
Thank you, Chairman. I want to thank everybody for coming and testify this morning. Helpful information that's been provided, and I appreciate all of your service. Wanted to touch a little bit on some of the focus of a number of hearings that we've had on this committee over the course of the past year or so with regards to internet and internet companies. So following the revelations of Facebook's data sharing practices with third parties, and specifically for third-party app developers, which led to Facebook users data ending up with Cambridge Analytica, there were a lot of discussion around the FTC's 2011 consent decree with Facebook. That consent decree was entered into following Facebook's earlier failure to notify its customers of its data sharing policies, and the recent Cambridge Analytica issue appears very similar. Chairman, I'm not going to ask you details. I imagine you're not going to get into the details of an investigation, but I believe you have confirmed that the FTC is investigating whether Facebook violated its consent decree. Is that right?
Yes, that's correct.
And so, sir, under the consent decree, Facebook was required to get biennial independent audits certifying that it has, in fact, a privacy program in place that meets or exceeds the requirements of the FTC order, and to ensure that the privacy of consumers' information is protected. Given that requirement, it's a bit troubling to see that the FTC didn't discover the Cambridge Analytica issue earlier. So, again, I know you're not going to discuss the ongoing investigation, but this is a circumstance in which the FTC is investigating the acts of a company that is subject to a consent decree. Is the investigation limited to whether the consent decree was violated, or will the FTC also consider whether there were new unfair or deceptive practices?
Thank you, Congressman. It's like you said, it is an ongoing investigation. We publicly announced that. But what we can't do is we can't discuss the particulars of the investigation itself, and so I'm sorry, but I can't comment on that.
Okay.
Congressman Kennedy, though, I just want to add, FTC orders typically do not preclude the agency from investigating conduct outside of those orders. So if you review the wide swath of orders that we have entered into over the years, we typically do not handcuff ourselves to the four corners.
So just the four corners of the scope of that. Thank you. I appreciate that, Commissioner. So to reiterate a couple of the points that were made earlier, if new unfair deceptive practices are in fact found, a repeat offender could then be subject to civil penalties for those violations. Is that correct?
Yes.
So thank you. I also want to understand whether the FTC takes into account public statements made by those companies. Commissioner, you might have just touched on this point. But Facebook has made public statements that is investigating all third-party apps to determine if there was, in fact, misuse of users' information. Contrary to that statement, though, it's also been reported that Facebook has not even been able to access data regarding Cambridge Analytica to understand what happened in that case because the company and the data are located abroad. Again, without getting into the details of the current investigation, I respect that, Chairman. Do you consider those public statements as commitments made to consumers?
So let me just say, without tying it to a specific case, we look at everything. We look at what they say in their public documents. We look at what they say in their advertising. We look at what they say on their website. It's the whole range. So we would look at everything.
Okay.
Congressman, if I may.
Yeah, please.
I apologize for interrupting you. One of the things that I talked about in my oral statement earlier was the importance of Congress reauthorizing and eliminating the sunset in the U.S. Safe Web Act. You mentioned access to data abroad without, again, speaking to the specific case. That is a very important tool, and so we really do urge you all to consider that.
I appreciate the insight, sir. Last bit, and I think one of my colleagues touched on this as well. Google has told the public that it would stop scanning personal emails. Of course, most consumers probably didn't know that that was happening. But now we hear that Google does allow third parties to scan emails. Do you review those public statements for violations of either Section 5 generally or of a consent decree?
Yeah, we review everything. So that's one of the ways we start investigations. We see public announcements or public statements, and we get complaints. So we consider everything.
Okay. Chairman, thank you, and thank all the commissioners for being here. Appreciate your testimony, and I yield back.
Thank you very much. The gentleman yields back, and as agreed upon, we're going to take a 5-minute recess at this time and come back in at 10 till the hour. Thank you. like to reconvene the subcommittee to order, and at this time I would recognize the gentleman from New Jersey for 5 minutes.
Thank you very much, and good morning to the distinguished panel. I championed the Consumer Review Fairness Act in 2016 to protect consumers' ability to share their honest reviews and opinions about products, services, or conduct in various forums, including social media. There has been growth and influence of search and social media since the bill became law. Much has changed since the FTC closed its Google investigation in 2012, and I ask the panel, beginning with the chair, what is your view on how best to maintain competitive markets and better safeguard consumer reviews? So
let me just say that that piece of legislation is terrific.
I hope this is being recorded.
Okay, I stick with that statement. So one of the key things, as I described a little bit earlier or alluded to, in terms of competition, is that you need good information. Good information allows consumers to make the best choices, and the reviews are just terrific in that regard. They really help spur competition. So that's terrific, and we are very much looking to and have enforced under that statute.
Thank you. Would others on the panel like to comment? Yes, of course.
Yes, thank you, Congressman. I think that legislation was also very, very beneficial, and I was at the commission when we brought the case against Roca Labs, saying that that was a violation. But I also want to mention, in addition to making sure that consumers are free to express their opinions, we want to be sure that when opinions are expressed, but they're paid for by a sponsor, that's clear to consumers too. So the FTC has engaged in a lot of enforcement and consumer ed and business warning letters to make sure that reviews, if they're sponsored, are labeled as such.
And is that a more recent addition to this whole issue, the fact that you have required there be a disclaimer or whatever the appropriate word would be for the fact that some are being paid?
So it's not recent, but it is. We've given additional guidance for the new, on Twitter or on online to make sure that the old rules that have always applied, that people understand how they apply in the new economy as well.
Thank you very much, Commissioner. Other comments? Yes, Commissioner.
Just briefly, I just want to associate myself with the comments of my colleagues and thank you for your work on that really important legislation.
Thank you. It's based upon the fact that there was a review of, I think, an orchestra at a wedding, and there was some discussion that those who might purchase that service had to sign a form saying that there could be no disparaging review online, which of course I think appalls the American consuming public.
I agree, and I also want to share that one useful provision of that bill, as well as some other bills that have been passed on a bipartisan basis, is also allowing our state attorneys general to enforce it as well. We don't have the resources to do everything, but sometimes we won't be able to catch every orchestra violation, but the more we can rely on our state partners, the better.
Thank you. Without commenting on any particular company or investigation, if a company is operating under a consent order and found in violation of the agency's data security or privacy rules, does that affect the assessment of fines and penalties? Whoever would like to begin.
So typically, violations of orders allow the FTC to seek from a court injunctions, equitable relief, which can include consumer refunds, as well as substantial civil penalties over $40,000 per violation. So we have the discretion in many ways of when to seek it and how much to seek, but enforcement of our orders has to be a top priority.
Thank you. I ask these questions as the FTC continues its investigation into Facebook. During my questioning at this committee's hearing with Facebook CEO Mark Zuckerberg on April 11th, I indicated that Facebook's actions leading up to the Cambridge Analytica hack may have violated the consent agreement Facebook struck with the FTC in 2011. News reports since that hearing have highlighted other questionable practices at Facebook. This has strengthened my belief that the company has routinely violated its promise to obtain express consent from consumers before sharing information with third parties. I realize you can not comment on that as members of the commission, but that is my considered view, having reviewed the matter. Thank you, Mr. Chairman. I yield back.
Thank you. The gentleman yields back. The chair now recognizes the gentlelady from California for 5 minutes.
Thank you very much, Mr. Chairman. Last week in the Telecom Subcommittee, we discussed the different frameworks governing consumer privacy. Current privacy rules for the telecommunications providers, for instance, require opt-in consent from consumers before that provider could share so-called CPNI with unrelated third parties for independent use. More broadly, however, it is often the case that an unrelated third party to an online platform can and does receive data on a consumer that visits that platform. Third-party analytics tools on a given website will send information on a user's visit to a third party and allows that third party to assess user data. So I believe that a necessary part of the data privacy discussion, maybe the most important part, could be addressing access to data by a third party with whom a consumer has no direct relationship or knowledge. Mr. Chopra, what role does addressing independent third-party data use have in the FTC's consumer protection mission?
Well, under our current authority, if that is disclosed, we may be frustrated in being able to combat that. But with respect to any privacy legislation that offers consumers affirmative rights to know where data is being shared, to know what it's being used for, and for consumers to be able to access that, if we were able to implement that, and some of these principles come from our work from nearly 20 years ago in 1999, I think that would be very effective for the marketplace.
So you're basically saying you need legislation.
We're doing what we can
Right.
with what we have, but we can't solve all of these problems with the existing law we have. This is why I really think we need more tools and resources to
So we have to be very specific, though, in our legislation to direct you, then. Is that correct?
Well, I'm not going to, many people know how to craft legislation better than me, but the extent to which you can provide the framework in which we can implement through rulemaking, that will allow us to be flexible as well as how the market changes. No one would have known the extent to which website trackers would be used 10 years ago.
Okay, any other comments? Okay, as you all know, regular HTTP connections sent in plain text can be intercepted and exploited by anybody or anything between a user and the website, including somebody using public Wi-Fi. So I'm pleased that HTTPS deployment continues to grow. HTTPS protocol can ensure an online connection between a consumer and a website is encrypted. And I'm interested if the Commission is looking at whether the same standard UI security indicators could be helpful in providing consistent, meaningful consumer information, no matter which browser you're using and whether you are using a desktop or mobile device. Common security indicators that are deployed consistently could be a step towards increasing consumer understanding as to when their connection to a website is not only secure but also safe. Entire panel, does anybody have any thoughts on how security indicators deployed by web browsers could promote consumer protection?
Well, I think the advancements in how we are securing website traffic are a positive step in the marketplace. We know from other sectors of the economy, particularly in financial services, that encryption and higher standards for website security continue to be far ahead of the rest of the digital economy. I don't necessarily know what we can do from a law enforcement perspective, but obviously companies that are maintaining sensitive data, financial health or whatever it may be, need to take steps to secure that data.
Mm-hmm. Any other rest of the panel, any comments?
I think it's important that we look at how consumers get information about the security of the entire chain. So the FTC has brought enforcement actions against browsers that weren't secure, against, that was the ACES case, against computers that had inadvertently, or they didn't understand that it was really providing a man-in-the-middle attack for adware in the Lenovo case. So I think we've paid attention to all links in the chain for
I think the
consumers.
consumer needs to know, and that's the part of it that we'd like to look at, and I hope you're looking at too, because they don't know, in essence, and that's what's causing a lot of the problems today, because they're unaware of what's protected, what's secure, what's not. So anyway, it looks like I run out of time. I yield back my time. Thank you.
Thank you very much. The gentlelady yields back. The chair will now recognize the gentleman from Kentucky for 5 minutes.
Thank you, Mr. Chairman. Thank you for holding this meeting, and thank you all for being here. This first one's for Commissioner Olhausen. Last Congress introduced, it was H.R. 5315, which is the CLEAR Act, which we had part of a series of bills that we put forward on commission process reform. And I think it was almost a year ago that the commission announced itself that it was going to announce a set of reforms for consumer protection investigations and was reportedly looking to reforms for competitive investigations as well. Has there been progress made?
So, yes, there has been progress that's been made. So we had our civil investigative demand reforms that I talked about at the beginning of my testimony that tried to give recipients clearer information and better guidance. We also reduced the time for civil investigative demand, gave a little more time to respond. We've gone through, under my leadership, and we closed a number of investigations. But one of the other things that we did is we went through and looked at all our data security investigations, and privacy, the ones that we closed, and we distilled from that lessons about what steps companies had taken where we found it gave reasonable security, and we issued that in an updated guidance called Stick with Security. It gave us 10 additional lessons to supplement our Start with Security brochure.
Okay. Well, thank you. And Mr. Chairman, do you have any comments on issues the committee should be considering in just terms of process reform as well?
Of process, also on the competition side. So one of the things that's been reported publicly is that the merger investigations seem to have gotten longer, at least according to some measures. So one of the things we're looking at is actually developing a tracking mechanism to see how long they are in fact taking and why they are taking as long as they are, and then allow us to determine what we can do to make them more efficient and less burdensome.
Thank you very much. And I'm going to shift gears to the chairman as well. I know that we have, particularly with older folks, we've advertised and talked. I mean, our office has tried to put out, when somebody calls you, never give any information over the phone. Hey, we're your bank. We need to fix your account or whatever. We do that. But the concern that I have is these fake websites when you go online and you're seeking the information, and you're trying to engage with a hotel chain or to get a reservation or whatever, and you got to give information to confirm rental car, any of that, any consumer, actually, retail business. So just interested in how we know the identity of a website. One, is there, it's a committee, I know the committee is looking at how websites or identities confirmed. And the question is, what tools can consumers use to confirm they own a real website where they intended to go instead of a phishing site? And is the green, I think it's the green padlock that should be next to the site, is that secure? Is that something we should look for? Or any of y'all want to, anybody that's in that area, look for that, talk about that. Is there any, talking about secure websites, is none of that here? Okay, I guess that's not a question.
Congressman, if I may just very briefly, you had asked about other process reforms. I think I would be remiss not to bring up the Sunshine Act. While that law has a really great name, the way it operates today, it inhibits our ability as a commission to talk to each other. And so I just forward that for your consideration.
And how's that detrimental?
Well,
I'm not challenged. I'm asking if you to.
Sure.
An example of you would like to talk with each other.
If 3 of us want to talk together about an important issue, or 4 of us want to talk together, unless we, of commission business, unless we publicly notice it in advance, we can't meet. And while there are some really important meetings that take place that are noticed, the daily back and forth can also be important.
Yeah, the ability to informally meet without having to, in advance, schedule a full commission meeting would be enormously helpful.
Okay, so
it allows us to kind of work through issues much more quickly and without delay, as opposed to actually scheduling a formal meeting.
So the idea was if you're going to take any action, then it would be noticed, but you can't even like.
We'd have to vote. We'd have to vote.
Okay, any action would be important. Let's see that.
To be clear, we're talking about informal conversations.
I understand what
To
you're
take
saying.
any legal action, yeah, of course.
Yeah, you can't. I've seen city commissions over in a room or something. They say, "Oh, we got one commissioner need to step out of the room to talk about something."
Happens.
And that's what. So there only can be two instead of three. When I'm talking to them about different business, I've seen that before. And they literally do that. They don't take advantage. They send somebody out of the room so they don't have the quorum or something moving forward. But it does seem like, can we not just talk about what issues are important to the city? That's not an action that's being taken and moving forward. I see your point to that. Yield back.
Thank you very much. The gentleman yields back the balance of his time, and the chair now recognizes the gentlelady from New York for 5 minutes.
Thank you, Chairman Latta and Ranking Member Schakowsky, for convening this morning's hearing. A pleasant good morning to all of our commissioners, and a special welcome to our newest FTC commissioners. Your role is more important now than it has ever been before. The American people count on you to protect their data, privacy, promote competition, and much more. There are so many pressing issues and changes happening under the FTC's authority daily. I can say that I'm very anxious to hear your answers regarding these issues and the significant changes. So I'd like to start with the issue of privacy and direct this question to Commissioner Chopra. When it comes to privacy, there are many changes that need to be made to protect American consumers. Over the past years, discrimination online has been rapid, resulting in the marginalization of struggling families and communities. So can you please talk about the impact that the lack of meaningful privacy protections has on consumers, particularly those in underserved and low-income communities?
Yeah, so 50 years ago, Congress had a debate about secret databases that were making decisions about our lives, about where we could live, about where we could work, and about what loans we could take. We passed the Fair Credit Reporting Act in 1970 to advance new levels of transparency, to give consumers redress when there are mistakes. In today's digital economy, decisions are increasingly being made through data sets that we could have never imagined. It's no longer a manila folder world, it's a digital world. And in many cases, it's very hard for us to look at what was the data that was being used. With machine learning and algorithms that are constantly changing, it's hard to audit and hard to see when maybe those mechanisms are reinforcing biases rather than leading to more inclusion. The FTC has done work on big data and inclusion issues, and I'm concerned that our existing laws to prevent discrimination can't really be easily used when it comes to how technological choices, how technology is affecting the choices of firms in our economy, particularly with employment, housing, and credit.
So what can the FTC do to make sure that these consumers are protected? And do you feel that the FTC has the resources, expertise, and authority necessary to protect these consumers?
Well, we do have one. We have the Fair Credit Reporting Act. We have the Equal Credit Opportunity Act. We have not brought a case in a long time in the Equal Credit Opportunity Act. I would like us to energetically enforce those two laws. But truthfully, on the second part of your question, my answer would be no. I don't think we have the resources and authority to confront some of the issues you're raising, particularly with respect to privacy and data security.
Okay, well, I think that, Mr. Chairman, this is something we need to take a look at because it's only something that will become more insidious over time. Net neutrality and the FTC's authority is an issue that I believe is on everyone's mind. So let me just extend this to the panel. Would you state or believe that the recent Supreme Court decision in Ohio v. American Express has affected the FTC's ability to police anti-competitive behavior and net neutrality violations by broadband providers?
I'll answer first. I don't think so. I think the Amex case is extremely narrow. I think it really, the basic crux of it is limited to situations where there's a multi-sided platform that effectively involves a transaction, where the platform is providing a service to both sides at the same time in the same way, basically. And so I think generally that's going to apply to very few situations.
That it serves a two-sided market, edge providers or interconnecting parties on one side and consumers on the other. Does the American Express decision potentially preclude effective FTC enforcement against anti-competitive conduct against edge providers?
It might depend on the very specific facts, but in general, I would think not.
Okay, very well. Former FTC Commissioner Terrell McSweeney has suggested creating a Bureau of Technology at the FTC. Does the Commission have sufficient resources and staffing to protect consumer privacy in the digital age, and were resources an issue in failing to enforce the 2011 consent order?
We can't talk about an existing investigation, but we can say that, so we have numerous ways of getting the technology help that we need. So we have an Office of Technology Research and Investigation, which has, I think, about 8 technologists in it. We frequently contract with outside parties to get technology resources, and we hold workshops and seminars where we bring people in to educate us about new developments in the technological area.
Very well, Mr. Chair.
Can I jump in, Congressman? I do think I would lend my personal support to the idea of a Bureau of Technology. I think it is the kind of thing we could really benefit from, and I am concerned that with our current resource constraints to set something like that up, we would have to be taking resources away from other important work that we're doing. So it is an area where I think we could really benefit from some injection of more resources.
So we're looking into that. So we actually are affirmatively evaluating whether to create a Bureau of Technology, and that's just in process. So I'm not sure how that's going to come out. There's a group of technologists that are embedded in the Bureau of Consumer Protection, and so they're already there. And so a question is whether we need to have a commission-wide bureau as opposed to one that's just in one of the bureaus.
And whether, in fact, the workload is
yes,
a burden to those who are already in that space.
Correct.
Mr. Chairman, I yield back.
Thank you very much. The gentlelady time has expired. The chair now recognizes the gentleman from Indiana for 5 minutes.
Thank you very much, Mr. Chairman. As a physician, I'm concerned to hear reports that the DOJ may not challenge the CVS-Aetna merger. In an industry, the healthcare industry, that already lacks price transparency and in many areas competition, this vertical merger could increase anti-competitive practices. I'm not passing any judgments on the merger at all, up or down. I'm just voicing a few concerns, and then I have a few questions. The merger could potentially lead to Aetna customers receiving some pressure to fill prescriptions at CVS and to visit CVS walk-in clinics instead of other pharmacies or clinics, limiting real choice for the consumer. In addition, Caremark, owned by CVS, is one of the largest PBMs, pharmacy benefit managers in the country, and as you likely know, insurers hire PBMs to negotiate prices from drug manufacturers. The top 3 PBMs manage the drug benefits for approximately 95% of the American people. The merger might incentivize Caremark to secure better deals from Aetna while potentially increasing costs for other companies. While I understand that the DOJ is currently investigating the merger, I want to get your perspective, not particularly on this merger, I'm getting to my point here. I want to get your perspective since the FTC also has jurisdiction enforcing federal antitrust laws. So to the panel, what are your thoughts on this type of vertical merger in the healthcare industry? Again, not specific to this, but in general, in the healthcare industry and other industries. Particularly in healthcare, I'm very concerned about this because, as you know, as a country, we're struggling to get healthcare costs down and provide coverage for all of our citizens. So I guess I'll just address that to the panel. What are your thoughts about this type of merger in the healthcare space?
So let me say first that the healthcare industry has been and will continue to be an enormous emphasis for the FTC for all of the reasons that you just described. So we're very focused on this part of the economy, and we're very much looking out for the consumer here. So in terms of the vertical mergers, they turn out to be very, very fact specific. So sometimes they can be efficiency enhancing and beneficial for the consumer, even maybe when the companies involved are relatively large, but sometimes they can be very harmful for the consumer. And so, the job of the Antitrust Authority is to determine, which is which, and act accordingly.
I agree that healthcare is enormously important to consumers, and it's an enormously important part of our economy, and thus an enormously important and focus at the FTC and healthcare enforcement in general. Regarding vertical mergers, I agree with Chairman Simons. They are intensely fact-specific, but I would mention it's outside the healthcare space, but we recently just had a vertical merger where we had a remedy. We required a behavioral remedy in the Northrop Orbital ATK matter. So there can be problems in vertical mergers, and where there are problems, the merger should be stopped, or maybe a remedy should be proposed that takes care of that problem and allows the efficiencies to occur.
Yes, sir.
Thank you for the question, Congressman. I agree with my colleagues that healthcare has been for a very long time and will remain a focus for this agency. I'm very proud of the work that our staff have done in fighting all sorts of anti-competitive conduct in the healthcare space and ensuring that mergers work for consumers. Experience and economic learning teach us that verticals can be very good for consumers, but the specifics depend on the facts. And that makes it really important that we, as law enforcers, pay attention to trends in that sector of our economy, look at how companies are changing their behavior, look at how they're combining, and stay on top of them when we fear that there may be anti-competitive effects.
I think the structure of the pharmacy benefit manager business raises very serious transparency and conflict of interest issues.
My colleagues have said basically everything I was going to say. I was going to add a point that I think in healthcare in particular, consumers are frequently frustrated and competition is frustrated by a lack of transparency, as Commissioner Chopra mentioned, and that's particularly true with respect to pharmaceutical benefits.
Okay, quickly, Commissioner Phillips, this committee is very focused on ways in which companies and devices collect information about consumers. As I've raised in several hearings, I have specific concerns with cell phones and other smart devices listening and collecting information, and then that information being used to deliver targeted ads, and this happens to all of us all the time. Is this something you're concerned with, and I know you are, and will it be an issue that the FTC makes a priority?
I think it's one of those economic trends that I mentioned a moment ago outside the healthcare space that very much is at the front of what we're looking.
Okay, thank you very much. I yield back.
Thank you. The gentleman's time has expired. The chair now recognizes the gentleman from Texas for 5 minutes.
Thank you, Mr. Chairman. Both thank you for holding this hearing, also for our ranking member. I'd like to talk a bit about our robocall problem and consumer fraud. As you know, robocalls and failure to do not call registry are some of the top complaints received by the FTC and by members of Congress and our constituents, particularly older Americans. Older Americans lose more money to fraud than younger age groups. According to the FTC's Consumer Sentinel Network data book, Americans ages 50 and older are reporting a median loss of $1,092, over 2.5 times the median loss for Americans in their 30s, for only $380. Chairman Simmons, out of all the complaints received by the FTC on these calls, and can you provide a rough estimate on how many come from U.S. companies or individuals and how many come from overseas?
Thank you for the question. We're very interested in that, but unfortunately, the data that we have access to doesn't allow us to determine that. If I had a guess, I would say it's probably largely coming from overseas.
Well, when my wife heard the hearing today, she said she got a robocall and somebody was speaking Chinese to her. I don't know how that would be good to try to call us in Texas, but
you know, that's one of the problems, really, is that the do not call rule has been superseded by technology, right? Technological developments. You can have the telecommunications costs have come down so dramatically, and the computing costs have come down so dramatically that blasting out millions and millions of calls is so cheap.
Do you know how many defrauded older Americans receive consumer redress from the FTC? If you don't know, if you just get it to us, because I'd like to, because a lot of us do senior town hall meetings, and they want to know about Social Security and Medicare, and then they say we're tired of robocalls.
We're all tired of robocalls.
Yeah.
And actually, one of the things we think would be really helpful in that regard is to give us jurisdiction over common carriers because some of them we think are facilitating robocalls, and we could challenge that.
I've understood that, and I don't have any opposition to it, but I know when we get the FTC and the FCC, it's somehow, and our committee has jurisdiction over both of them, so you're talking to the right committee. What more could the FTC do under current law to protect older Americans from fraud?
We do a lot. So we have enforcement actions. We have outreach, community outreach. We have website on our website. We have consumer materials for the elderly, and we do sweeps. We recently conducted a sweep that dealt with the elderly. Or actually, there's a task force now that the DOJ is spearheading that we're involved with. That is one of the communities it's geared to help is elderly.
Is there a way that could the FTC partner with the FCC on a joint effort, particularly for seniors and older Americans?
We would certainly be happy to talk to Chairman Pai about that.
Okay. I'll bring that up at our telecom subcommittee. I think that's that elder abuse is an issue, and that's a big one I know we all hear about. And Mr. Chairman, I'll yield back the balance of my time.
Thank you very much. The gentleman yields back. The chair now recognizes the gentleman from Pennsylvania for 5 minutes.
Thank you. In May, the FTC and the FDA sent 13 warning letters to retailers, manufacturers, and distributors of vaping nicotine products to stop marketing these products to children. As we have recently seen, vaping, some people call it juuling, is increasingly becoming pervasive in our schools. As FDA Commissioner Gottlieb announced in April, it is well established that nicotine can, quote, rewire an adolescent's brain, leading to years of addiction, end quote. Two questions, Mr. Chairman, and if anyone else would like to weigh in. Does the FTC agree with Chairman Gottlieb's statement that there is no acceptable number of children using tobacco products? My guess is that's an easy answer. But it is followed by this question. Would it be a powerful deterrent to give the FTC the authority to fine a party marketing these vaping products to children for their first violation?
I would think any financial penalty would be more of a deterrent than no financial penalty.
This comes on the heels, I think, of Commissioner Chopra. Comment about the difference between having the ability to fine versus working on a...
Correct.
Yes.
So if there was a rule in place, or if we had that authority, we would certainly be able not only to just tell someone stop, we would be able to seek penalties and other remedies to...
What would that rule look like, and how could Congress carefully tailor that so that you don't have all the freedom that we fear you could have?
Yeah, well, I think actually some of the comments Commissioner Gottlieb has made on this, I think that would really inform how you might prescribe it, because there is some changing science, there is some changing delivery mechanisms of nicotine. We obviously are not, maybe someone is, but I'm not an expert in the tobacco market. But I think you would be able to put the guardrails around it to make it as narrow, as wide as you want. I just want to make sure that whatever you do give us, we vigorously enforce.
Yeah, I mean, I think the broader application of that example is, from a marketing perspective, how do you fashion how you would go about determining what isn't a violation, and just how broadly would that power be vested upon you to go into the marketing space and say, we're going to slap you here, we're going to fine you here, versus we're going to enter into a consent decree there. And is it so broad as to say any marketing, or is it going to be sort of certain types of marketing or certain products?
Right. So actually we do enforce...
Because I gave you the easy example.
We do enforce a Children's Online Privacy Protection Act, and there's implementing regulations. And as part of that, we help to communicate to the marketplace what is considered dealing with online transactions with children. We specify that. So one of the advantages of putting some meat on the bones through implementing rules is that it gives all market participants a clearer sense as to what is inside and outside the bounds, rather than just waiting for enforcement actions.
Right. I have another question for you. I'll ask that, and if you want to follow up on this one. The Smart IoT Act was approved by full committee. We are focused on both the benefits and challenges a more connected world brings. Can you talk about the actions and initiatives the FTC has or will take to promote consumer protection with respect to IoT devices?
Yeah, so we're active in that space. As Commissioner Olhausen mentioned, we've had a couple of orders there already. And we continue to look at that. We've also had an IoT workshop, and so to educate ourselves and to look at what we should be doing going forward. So we are very active in this area.
Ms. Olhausen, you were mentioned that in your opening testimony. Anything to add to that in terms of what you're doing in the IoT space?
I think it's a particularly interesting area, and certainly our enforcement actions against the first connected toy case in VTech, other ones that we brought about, internet-connected cameras, and the routers, as well as the policy inquiries, because Internet of Things can have enormous benefits for consumers and for competition. So we want to draw the lines in the right place to make sure consumers are protected, but that innovation can still continue in the market.
Do you have the type of authority vested in you to be able to do that, or have you found that lacking in your diligence?
I think for the Internet of Things, the cases we've been able to bring, I think, do show that we do have, sufficient authority there to teeth, and got the attention of the industry about, making sure that they don't have flaws and that they're looking at things. But it is a challenging area because they are often disposable products. They don't necessarily get updated a lot. Mm-hmm. So there may be a benefit for some industry involvement as well.
I appreciate your feedback. I'll yield back.
Thank you, the chair. We now recognize the gentleman from Florida for 5 minutes.
Thank you, Mr. Chairman. I appreciate it. To the panel, well, this is actually for Chairman Simons. The FTC points out it serves its dual mission through vigorous enforcement, education, advocacy, and policy work, and by anticipating and responding to changes in the marketplace. Outside of law enforcement, are there past or recent examples of policy work, reports, and workshops related to online privacy that you can share with us today, please?
I'm drawing a blank right now, but maybe one of my colleagues could help me.
Just in the past year and a half, we actually have done 6 workshops and major policy efforts looking at privacy and data security, things from industry guidance. We did a student privacy and EdTech workshop. We did an informational injury workshop to explore the boundaries of the types of injuries consumers may suffer. We did an identity theft workshop, a connected cars workshop going to the Internet of Things. So I think we have done quite a bit in this space just in recent time, and that's just building on all the other years of work we've done in this area.
Okay, thank you. And Commissioner Phillips, does somebody else want to add something?
I was going to.
Okay, go ahead, please.
I was just going to say the chairman also has announced a very ambitious set of hearings to begin this fall on a variety of issues, including those.
Okay, very good. Thank you.
And we also, I would encourage you, our 2012 privacy report, as well as a later report on data brokers. Those two, I think, provide a real consensus roadmap on a lot of the initiatives that could be pursued on a bipartisan basis, in my view.
All right. Do you have anything to add? We're okay? All right,
I'm
let's
good.
go on to the next one then. Commissioner Phillips, do you believe American consumers fully comprehend exactly how much personal, health, and financial data is being collected on them? What can the FTC do to better educate consumers on data collection activity that industry is engaged on? I mean, it's up to the individual, but they need to get all the facts. So if you could answer that, I'd appreciate it.
Thank you for that question. I think that's a really important one. I can't sit here and tell you that every individual fully comprehends the way which data are being collected, how those data are being used, or how those data, as Commissioner Chopra said earlier, are being shared. You're right to note that consumers have access to that information, and consumers also have certain expectations. For instance, my ability to use an app, let's say, that guides me through traffic and tells me where the traffic jams are going to be. I know that it must have information about that traffic from drivers like me who are supplying it. That balance is a very important one, fostering the innovation as we want to do, and also helping to keep consumer understanding in line. I think that's going to be one of the biggest challenges that we face over all of our tenures. I know it's going to be a topic that we're going to be talking about in years to come, and we look forward to working with you on that.
Thank you. Yes, someone else wants to add, but would you recommend that the consumer assume that all their data, that particular data, would be collected when they make an informed decision as to whether they want to log in or log out, and a lot of times they don't have the opportunity to opt out?
Let me sort of start with the second one. I hope in my own life, and I hope that everyone in their own lives always make informed decisions. That's not always how we do things. I will admit to you that I have repeatedly in the last few weeks clicked on any number of accepts online. And now I've forgotten the first part of the question. I apologize.
I'll jump in.
Just, yeah, should I repeat the question?
If you don't mind.
Our consumer, would you recommend the consumer assume?
Yes, assume.
Yeah, assume that this data is collected on them.
The short answer is yes. As we engage with the digital economy, we derive tremendous benefits from that. Almost every minute of every day of our lives. And in many respects, we are sharing information, and so that is a pretty reasonable assumption.
That's pretty sad, though.
Yeah, would you like to add something?
I mean, it's pretty sad that we have to assume helplessness. Yeah. So I understand we may want to warn consumers that anything can be up for grabs, but that can really lower consumers' confidence in engaging online or engaging in spaces where they just think everything's going to be taken from them. So we have to make sure that we are also not scaring people from engaging in productive transactions for their lives because they fear that someone's always spying on them. And this is why we have to put into place the right framework to protect privacy.
And from an enforcement perspective, it's our obligation to ensure that when companies represent to consumers that they are collecting data in a certain way or not collecting data in a certain way, that they're living up to those representations that they make. And that is an area under the current law where we can and do enforce.
Yeah,
if I could just weigh in. So going back to the FTC's 2012 privacy report, it talks about the importance of it being context specific. So if I'm sharing my location with the traffic app, I certainly understand that it knows where I am to route me around the traffic jams. But we have to understand that the consumer may not expect that that data will be used in other ways. So example, we brought an enforcement action in a case called Golden Shores, which is about a flashlight app, and it worked fine as a flashlight, but the consumers didn't know that it was also collecting their real-time location data and sharing that with marketers. So I think that is an important thing, is the context. Is the information being used in the way the consumer expects to get the service, or is it being shared, their sensitive data, being shared in some way that they don't anticipate? And I think that's where enforcement and guidance and policy concerns need to focus.
All right, I have a couple more questions, but I'll submit them for the record. I appreciate it, Mr. Chairman.
Thank you very much. The gentleman's time has expired. The chair now recognizes the gentleman from New Mexico for 5 minutes.
Thank you, Chairman Latta, Ranking Member Pallone, and Schakowsky, Chairman Walden, for holding this important hearing with our Federal Trade Commission oversight. When it comes to protecting consumers, I'm afraid that both Congress and the FTC have much more to do. Commissioner Simmons, I'm going to direct my questions to you, which I believe you should be able to address without getting into the FTC's active investigations. In September of 2017, the credit bureau Equifax announced a massive consumer data breach due to a vulnerability that the company knew about but failed to adequately address. Personal information, including social security numbers, birth dates, addresses, and in some cases, driver license numbers or partial driver's license numbers of almost 150 million consumers were exposed to illicit actors. Commissioner Simmons, is that correct?
I'm sorry, is that what?
Is that correct?
That's my understanding. That's consistent with what I...
And again, it's that Equifax announced the massive consumer breach.
Yeah, this is public information.
Is it correct, due to this breach, that the credit card numbers of more than 200,000 consumers were compromised, as well as other personal information included in the dispute documents of more than 180 consumers?
So I'm not sure if that was public. And so I really don't.
I believe that that was public as well, so we can verify that. We'll get that entered into the record.
Okay.
Is it correct that Facebook recently revealed that 87 million Facebook users had their data exposed to Cambridge Analytica?
I believe there are press reports to that effect.
Is it correct that in November of last year, we learned that hackers stole information of 57 million Uber drivers and riders?
I think that's reported as well.
So, Mr. Chairman, I'd like to submit a Business Insider article into the record. The article states that since January 2017, at least 15 retailers were hacked and likely had information stolen from them. They include Macy's, Adidas, Sears, Kmart, Delta, Best Buy, Saks Fifth Avenue, Lord & Taylor, Under Armour, Panera Bread, Forever 21, Sonic, Whole Foods, GameStop, and Arby's. Commissioner Simmons, have you ever shopped at one of these establishments?
Yes.
Me too. I think most Americans have. Commissioner Simmons, is there any reason to expect that there will be fewer data breaches in the future?
That's our goal, and that's what we're working for.
But the reason we're working towards that goal is because there's a concern that they could happen.
Yeah, and one of the things that we've discussed earlier is the need for civil penalty authority to act as an increased deterrent.
So building on that, Commissioner, can you detail what rules the FTC is currently developing to better protect consumers' privacy and data?
We don't have any rulemakings going on. We're engaged in enforcement to the extent our current authority allows us to do that, and we're as aggressive as we can under our current authority.
Does the FTC have rulemaking authority?
We do under Magnuson Moss, but it's very cumbersome.
But not in this space?
No, well, it's general.
Could the FTC use some support for authority to have more clear rulemaking authority to protect consumers' privacy?
I think through individual enforcement, we are able to make pretty clear what companies are supposed to do. So I think we're relatively effective in that regard. And the rule, I don't think we need a rule to make it clear what the companies need to do. I think the authority, the civil penalty authority, would act as a substantial additional deterrent.
So with some of the numbers that I rattled off, 150 million people exposed with Equifax, 200,000 consumers were compromised, 180,000 consumers here and there, 87 million with Facebook and Cambridge Analytica, 57 million Uber drivers. A lot of people are getting their information stolen. Commissioner, are you aware of any recent legislation that's been passed by the Congress and signed into law that would strengthen privacy protections for consumers?
You mean like COPPA?
Anything that you might be aware of.
So COPPA would be one. That would be a relatively recent one. I don't know, what am I missing?
Well, it's not recent, but there's the Fair Credit Reporting Act as well.
The reason I asked that question is this subcommittee, Mr. Chairman, held a hearing on Equifax in October of 2017. We had Mark Zuckerberg before the full committee in April 2018. It's now July. When these breaches took place before the holidays, there were assurances that the Congress would act to provide more certainty to the comments that Commissioner Chopra shared, that you need to instill confidence. Nothing happened. I believe, Mr. Chairman, that this Congress and this committee need to act before the August recess, need to act before the end of this year to be able to get more comprehensive privacy legislation adopted. And I believe our constituents and the American people deserve better. And I thank everyone for their time, and I see my time has expired.
Thank you very much. The gentleman's time has expired. The chair now recognizes the gentleman from Georgia for 5 minutes.
Thank you, Mr. Chairman, and I appreciate you letting me sit in on this. Thank all of you for being here. You have a very important job, and certainly Certainly, it's very important to consumers. Full disclosure, currently I'm the only pharmacist serving in Congress for over 30 years. I practiced in retail pharmacy, and I'm very familiar with what's going on in that. And I wanted to ask you, I want to talk specifically about PBMs, pharmacy benefit managers, where 3 companies control 78% of the market. First of all, Mr. Simmons, you and I met after you became director, and we met and we talked about the anti-competitive nature of this. Would you consider 3 companies owning 78% of the market to be a problem?
That's certainly a market structure in which you might find and we might look for anti-competitive conduct. As I mentioned before, in terms of antitrust enforcement, the places you look are the places where there are small numbers of firms with large shares.
Right.
And this would be such
One of the things that confuses me is when we talk about vertical integration and horizontal integration, and oftentimes you tell me, well, vertical integration's fine, and we just have to worry about horizontal integration.
No,
well,
I wouldn't say that.
Well, I appreciate you correcting me, because that's probably a misnomer that I want to dispose of, because the vertical integration as we see it right now, all of you know what's going on. All of you know what's going on. We've got the top 3, those 3 that I mentioned, PBMs, that control 78% of the market. You got CVS Caremark that now is buying Aetna. So all of a sudden, you're going to have a vertical integration that includes the insurance company owning the pharmacy benefits manager, owning the pharmacy. Now you've got Cigna buying out Express Scripts. Did you know that Express Scripts, according to volume, is the 3rd largest pharmacy chain in America right now? So now you've got number 1 at CVS, you've got number 3 at Express Scripts. Cigna's going to be the insurance company. Express Scripts will be the PBM, and they'll be the pharmacy. And that vertical integration, you yourself, Mr. Simmons, the FTC investigated in January of 2012 regarding patient steering from Caremark to CVS and what was going on there. We see it. I've got numerous examples that I can share with you, and I will be glad to share with you. And yet they hide under the auspices of a lack of transparency. I mean, this is the most opaque system that's known out there. The most opaque system, because, and they hide behind that, and their profits have been just outrageous. In fact, I don't like to read, but I'm going to read this. According to data from CMS, between 1987, when PBMs first became involved in this, when they were formed, and 2014, expenditures on prescription drugs have jumped by 1,100%. There's been a 1,553% increase in per-employee prescription drug benefit costs since 1987. In the last 10 years, the 2 largest PBMs have increased their profit margins by nearly 600%. Now, folks, I'm not opposed to anybody making money. But if you ask them, what is your mission? What is the mission of a PBM? They'll tell you it's to control prescription drug prices. Well, how's that working out? Why is that an initiative of the President of Health and Human Services right now to lower prescription drug prices, if they are fulfilling their mission? And yet they're hiding again, and this is what we look to the FTC to do. Am I wrong? Is that not your responsibility? Should I be talking to some other agency?
Well, it's partially our responsibility. So we look at anti-competitive conduct, and if they're engaged in anti-competitive conduct, we should be challenging it.
So I had, just a quick story. I had a pharmacist that shared a story with me that he filled a prescription at his drugstore for his wife, who was covered under Caremark insurance. That night, he got a call at his home from CVS saying, if you get it filled at our pharmacy, you can get a lower copayment. Now, is there supposed to be a firewall? What happened to that firewall? This was his wife.
I understand.
That's the kind of behavior that's going on here, and we look to you to help us with this, not because of the pharmacy, but because of the consumer. It's the consumer who's suffering here. Because as you do away with the independent retail pharmacies, you do away with choice, less competition, that's not going to benefit the consumer at all. It's just very frustrating when you have a profession where the PBMs are responsible. They create the pharmacy networks. They decide who's going to be let into that network and who's not going to be let into that network. They direct the patients to the certain pharmacies, and if they own the pharmacy, who do you think they're going to direct it to? My one question is, who's supposed to be watching this? I thought it was the FTC. Can I get a commitment that you'll look into this?
We are looking into it.
You're looking into it now.
You and I had a meeting, and
we did.
And I took what you said to heart.
Thank you. I look forward to continuing that conversation with you.
Thank you very much.
Thank you.
The gentleman's time has expired. The chair now recognizes the gentleman from Maryland for 5 minutes.
Thank you, Mr. Chairman, for the opportunity to participate in the hearing. Just before I start my questions, I want to say I agree 1,000% with my colleague. These mergers are kind of out of control, and they're putting the consumer really in a very, very bad position. I want to thank you all for being here, for your work. This is an incredibly important commission in terms of protecting consumers, obviously, and the opportunities to lean in to do that, I think, are expansive right now, if you look across all the various areas of jurisdiction that you have. Commissioner, is it Simmons? Is that the pronunciation?
It's Simons.
It's Simons, okay.
One M, two S's.
I was wondering why everyone was saying Simmons.
But, you know, it's remarkable how often it's mispronounced, so I'm used to it.
Okay, so Commissioner Simons, I wanted to talk a little bit about biologic drugs and biosimilars. The FTC, as I understand it, doesn't currently have the authority to monitor agreements made between the manufacturers of biologics and biosimilars. And I wanted to know if you thought it was important that the FTC get that authority, and if so, why?
You mean in terms of like pay for delay and that type of thing? Yeah, that would be helpful.
I mean, my understanding is that if you look at the authority you have over the agreements between brand name drug manufacturers and generic drug manufacturers, where you can monitor this anti-competitive behavior, the pay for delay agreements and so forth, that you can have a significant impact on the overall cost to the consumer out there if you take those actions. Can you describe a little bit some of the tools you have when you go after those pay for delay?
Yeah, so
agreements?
The statute you're talking about requires that if there's any agreement between a brand and a generic, I think, that delays the marketing of the product, that they have to report that to the FTC. And those disclosures are a significant way in which the Commission finds out about these agreements and whether it gives a rough sense earlier, it tells us where to look for whether these agreements might be anti-competitive or not. So it alerts us, hey, these agreements, it's a brief description of what they are, and we can look at them and then figure out, okay, which ones look like they're problems, and we go after them.
It's incredibly important. I think there's a study out there that shows that while brand name drugs are about 10% of all drugs that are dispensed, I think that's including biologics in the equation, they make up about 72% of annual U.S. drug spending. So there's a huge amount of money on the line, obviously from patients directly and from payers like Medicare and Medicaid, government payers, that can be saved by monitoring these agreements, blocking these agreements. But it's really critical to get that same kind of authority with respect to the biologics and the biosimilars, because in the same way, those pay for delays are decreasing market competition. They're keeping the costs high. That's hurting patients at the counter. And I want to, again, commend you on the work you're doing with respect to the brand name drugs and the generics. But the Medicare Modernization Act of 2003, which gave FTC this authority, as you know, didn't extend it to biologics and biosimilar drugs. So I'll be introducing soon the Biosimilars Competition Act of 2018 to grant FTC that authority so that you can begin to monitor these deals, punish the bad actors, and hopefully deter many of these backroom deals from being made. In the first place, we look forward to any comments you all will have with respect to the proposed legislation, because we do want to give you that authority.
Thank you very much.
I wanted to switch gears really quickly. You've had probably 2 or 3 members ask you about your authority as it related to Facebook and that earlier consent decree, and I wanted to pick up on that a little bit. I was sort of struck that in a recent earnings call, the various Wall Street analysts were like peppering Mark Zuckerberg and Sheryl Sandberg about the implications of Europe's new privacy law, the General Data Protection Regulation, how it might impact the company and its earnings, Not one person, not a single analyst asked about the FTC's announced investigation into Facebook's privacy concerns, potential violation of the 2011 consent decree. So the market, in any event, doesn't seem to be taking that consent decree, your ability to enforce it and punish Facebook if you see violations, seriously from a kind of market standpoint. Actually, Commissioner Chopra, I'd like your perspective, if you could share it quickly, just about this issue of the Commission's credibility. I mean, to me, that treatment on the earnings call suggests that they're not taking it seriously. Can you speak to how the FTC could be taken more seriously on things like that and the tools that you could maybe use to do that?
Well, without speaking about the specific matter at hand, the FTC very energetically goes after companies that break the law. And when it comes to small-time scammers, we really do lay down the hammer. We seek bans of executives. We sometimes close down a business. I would like us to apply the law evenly, regardless if it's a small-time scammer or a big-time publicly traded corporation. And it's our duty, I think, to apply that law equally, and the market needs to see that we're willing to do that. Otherwise, the credibility of our orders and enforcement will not be as high as it needs to be.
Well, thank you very much. I appreciate that. I agree with you, and I think we do need to make sure the big guys receive the same kind of attention as the small guys. The public's confidence in the Commission, I think, is dependent upon that. Thank you, and I yield back my time.
Thank you. The gentleman's time has expired, and the chair now recognizes the gentleman from California for 5 minutes.
Well, I thank the chair and the ranking member. I thank the commissioners for your service with limited resources. It's a tough job. In recent years, we've witnessed numerous data breaches incidents from many companies like Facebook, Equifax, Target, Home Depot, LinkedIn, and Anthem. The FTC does have resources to help consumers who've been victims of data breaches. Commissioner Slaughter, what more could the FTC be doing for consumers?
Thank you for the question, Congressman. I think my colleagues and I have all spoken, particularly in the area of data breach and data security. Well, I don't want to say all. Several of us have spoken, no, I think all, actually, correcting myself, about how we could benefit from data security legislation, perhaps data breach notification legislation that gave us more specific authority and perhaps rulemaking authority with respect to data security and data privacy.
So that would be your specific recommendation, is that the FTC be given rulemaking authority?
Yeah, I think we've outlined, a number of us have outlined different issues different kinds of authorities that would be useful in different ways. Rulemaking authority is one, civil penalty authority is another. I think we do and we will go after violations of the law where we find them now, but deterring these problems on a large scale would be, we would be better able to do that with a little bit more authority.
Thank you. Commissioner Cooper, do you have anything to add to that?
Well, I think that you mentioned Target and some other large retailers. I just want to underscore, particularly with respect to stolen credit card information at these large retailers, this actually impacts a wide swath of our banking industry as well. Community banks, others who in some ways have to take those losses. So we require financial institutions, we require certain healthcare institutions to protect data. I think we in some ways need to level the playing field and make sure other big sectors of the economy are doing the same thing.
Thank you. Chairman Simons, facial recognition features are increasingly being incorporated into technology. However, just last week, Brad Smith from Microsoft stated that facial recognition technology should be regulated, which is voicing a great concern on this issue. What is the FTC doing to address privacy concerns raised by facial recognition technology?
Thank you for the question, Congressman. So this is a good example of something that maybe even a few years ago was not really considered sensitive information. And now with the development of technology, now it is sensitive information. And so one of the things we follow and are careful about is whether people are being misled about information that is sensitive information for them, and whether the companies have disclosed how they're using it in the correct way.
Thank you. Mr. Cooper, do you have anything to add to that?
Well, I agree with Chairman Simons. I'll just add, I think the potential for misuse with facial recognition implicates a lot of issues and values that we are not always best situated to combat. I don't know if I want to live in a society where everyone knows my movements at all time and where my face can be scanned and it can be used to decide other things about me.
You're here.
So it's something I'm worried about when it comes to misuse. I saw Microsoft's announcement about this. We will do what we can, but I want to be clear, we can't solve everything with respect to the issues with facial recognition. We have limited authority to do that.
This is an area you think Congress needs to get involved in?
Well, I think it involves a lot of issues beyond our narrow lens, including really our values as Americans and our civil liberties. And that is something that we want to enforce the law with respect to promises that are made or misuse of data in certain commercial transactions. But I think it's on you guys to really think about the big picture.
Okay, thank you. Chairman, I'm going to follow up on the Cambridge Analytica issue. The FTC entered a consent decree with Facebook in 2011, and in 2015 it was revealed that Cambridge Analytica illegitimately obtained consumer data, yet it was not until this spring that the commission announced it was investigating. Now, I realize you can't comment on Facebook specifically, but can you tell us what steps the commission is taking to improve how it monitors compliance with consent decrees?
Yeah, so this is, without saying anything about a particular matter, so this is another example of self-critical examination. So when this all came to light, one of the things we did was we started a task force to deal with potential changes in how we do our orders. So
and how you enforce those?
How we write them and how we enforce them.
Because, I mean, if you don't enforce them, there's no point in writing.
But also you have to write them in the right way. So you have to get the company committed to doing what it needs to do, and you have to, and also in terms of being able to monitor them properly. So writing the order is important, and enforcing the order is important. Both are important.
Thank you for that answer.
Congressman, if I can quickly add, sure. I think we all take enforcement of our order seriously. I will note that when Chairman Simons was his previous stint at the FTC, he achieved and obtained a very significant civil penalty against a large order violator, and I think we will continue with that spirit and use all the tools we can to correct violations of our orders.
Okay, thank you. Yield back.
Thank you very much. The gentleman's time has expired, and at this time, the ranker and I are going to ask one last quick question each, if that we agreed upon. Chairman, I was wondering if I could start to just ask my last question to you. I want to touch on an issue we've all heard about. We have seen advertisements that target the senior population. We've all seen or heard the lawsuit advertisements that proclaim that certain medications or drugs may cause complications and to contact the organization or law firm airing the advertisement. I also understand that these ads may at times be misleading or in some cases just outright fraudulent, leading potential physical harm. Is there an issue is this an issue that the FTC is focused on? And if you are, what is the FTC doing to prevent misleading or false ads?
Yeah, so this is potentially deception in a very sensitive area, and it also, because of the area it's involved in, it's something that we would do in conjunction with the FDA.
Okay, but this is something you're actively working on then.
Well, you've brought it to our attention, yes. So this is some of a concern, yes.
Okay. Well, thank you very much, and I'll recognize the gentlelady from Illinois, the ranker of the subcommittee.
As I mentioned in my opening statement, the European Commission announced a $5.1 billion antitrust fine on Google. The EU alleges, among other things, that Google forced smartphone makers to pre-install Google Search together with its Play Store and Chrome browser and sign agreements not to sell devices on rival Android systems. by imposing its bundled package on smartphone makers, Google arguably gave itself an advantage over its competitors. So Chairman Simons, I know that you have announced a series of hearings that will examine competitive competition policy. But as of right now, are there any limitations under U.S. law that would prevent the FTC from looking into Google's conduct regarding this kind of bundling? Specifically, do you have enough authority to consider if Google's conduct is anti-competitive?
Yeah, so thank you for the question. We do have enough authority to determine whether it's anti-competitive or not. And let me just say, we're going to read what the EU put out very closely. We're very interested in what they're doing. I had a conversation with Commissioner Vestager yesterday. So we're very interested in what the EU is doing.
So who is that person?
She's the commissioner. She's my counterpart of the European Commission's competition directorate. Okay, and but in terms of what they look at versus what we look at, their regulatory regime is a little different than ours. So once they find that a company is dominant, as I understand it, that imposes upon the company kind of like a fairness obligation, irrespective of what the effect is on the consumer. Our antitrust regime requires that there be a harm to consumer welfare, so the consumer has to be injured. So the two tests are a little bit different, but we're gonna look closely at what the EU is doing.
Thank you. I yield back.
Thank you very much. The gentlelady yields back. And seeing that there are no other further members here to ask any questions, again, we want to thank you all for being with us today and appearing before the subcommittee. Before we do conclude, I would like to include the following documents submitted for the record by unanimous consent. A letter from ACA International, a letter from the Electronic Privacy Information Center, a letter from the Coalition Trade Association, and a letter from the Internet Association. And without objection, so ordered. Pursuant to committee rules, I remind members that they have 10 business days to submit additional questions for the record, and I ask that our witnesses submit their response within 10 business days upon receipt of those questions. And without objection, the subcommittee stands adjourned.